All right, good morning, everyone. You may be seated.
Good morning, Judge. Yes, can you please turn on 11,
All right, good morning, everyone. We are back in session on State versus Ferriter. Let me have appearances this morning, please.
On behalf of the state, Brianna Coakley, Karen Black, on behalf of the state. On behalf of the defense, Theodore Rod and Crow Wanted, Ferriter present.
Okay. All right, just a couple things to address before we begin. Let me have counsel approach on sidebar. I have something I need to discuss outside the presence of everyone. All right, so before we bring the jurors out, court has received a motion to reconsider rulings. I'm not going to have argument on this. I find this somewhat unusual because it's literally a motion to reconsider almost every major ruling I've made during the course of this trial, so the motion is denied without further argument. All sides ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Okay. All right, you may go ahead and bring the jurors out. All rise.
Jury entering.
All right, good morning, everyone. You may be seated. All right, before I get started, Juror 5, I understand you've worked out your travel issues, so it's no longer an issue. I really appreciate you doing that. I was going to have to inform you this morning that I looked into whether there's anything in the system to compensate you for having to pay a change fee, and unfortunately there was not. So I thank you for having worked the issue out prior to my having to give you that news that you wouldn't be compensated if you did have a cancellation fee. So thank you very much for that. Couple things before we get started. We're still in the state's case, and as I indicated, right now we're expecting to go into next week. I've given another review of my calendar, so the schedule for next week is going to be 100% that we'll be back on Tuesday. We will be able to start early. Let me give you feedback. We will be able to start earlier each of the days next week. So we'll start back Tuesday. If it goes into Wednesday, we won't start in the morning on Wednesday. We'll start late morning, early afternoon on Wednesday, and if necessary, go into Thursday. I don't expect, even given how badly we've missed the estimate on the schedule on this, I don't expect that we'll go past Thursday. So as I said yesterday, you should plan on Tuesday most of the day Wednesday, starting in the latter part of the morning or maybe early afternoon, and then possibly Thursday. And that would, again, be dependent on how long deliberations take. We're still in the state's case, as I just said. Let me, before I move to that part of the proceedings this morning, just inquire whether any members of the jury were exposed to any media coverage inadvertently between last night and this morning regarding this matter, either in print or TV. Okay, let the record reflect again that no one indicated that they had been. So with that, is the state ready to continue with the presentation of its case? All right, and where are we with that, Ms. Black?
Right now, the state is going to start publishing State's Exhibit 17, specifically January 11th, 2022.
Okay, all right, you may proceed.
Sleep? A little bit. Alright, why don't you go to the bathroom and grab her clothes when you get done?
everything?
Yeah.
All right, let's go. You sit by me and do that. Grab that. Grab those dirty.
Yep.
Air needs to be off, right? It's water. Keep it over there.
Yeah, but get out one of them.
Still got that attitude?
Yeah.
Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here? You ripped it up? You ripped it off the wall?
Yeah.
Good job. I won the bet. I didn't think it'd last 3 weeks. Who are you looking for attention from?
No one.
Oh, well, somebody, because you wouldn't do it. Oh, it's so sad. So you're mad because Baba asked you about your tablet, about your Chrome pad, your Chromebook?
Yeah.
Well, you've been stealing and lying and running away and calling yourself Richard. You're lucky you have anything. Give me a fucking break. You want to get serious with me? Stand up. Stand up. You want to get serious with me? Oh, you're so, mad because Baba thought you were looking. Give me a fucking break. What are you Are you serious? I know it's a fucking lie. Because it's a joke. It's a laughable joke. Baba's mad at me because, mad because Baba was looking for something. Do you forget what you've done a short time ago? Do you forget that? No, you don't forget it. You're lucky you have anything. Maybe a ground with no carpet. Maybe no bed would be ideal for you. But you've gotten a ton of stuff. Oh, so you broke everything, huh? Just throw it all away. Did you rip books up too?
No.
No. So, who does this hurt? Not me. You know the answer is you, but you don't care. You want to show out like, oh man, why didn't you break the bus and break all that garbage?
There's something I know that I would be mad if I broke it.
I don't give a shit. I don't care. This stuff is for you. I don't need any of this stuff. I don't need this room. I don't need your shit every single day. You're going to come back and get mad, get happy. Okay, let's be good. Let's have fun. Let's have ice cream. Let's have a good couple days. And then let's get mad because you're on your device trying to look shit up that you shouldn't be looking up. But you can't quite get through there yet. You're trying to break it. So you get mad. Give me a break. Give me a break. You're going to finally give you a safe environment to get through these lessons. But when you get into the real world, because you're not learning shit here, and I don't need to deal with the shit that you go through, so you're going to buy yourself more time in here. And guess what? If you're going to fuck off in school, you're going to be kicked out quick. What happens then? Do you remember?
Yeah.
What? Yes, in this room, every day by the book. What's the book mean? Paper book, right? With pencils. You're going to get your education by a paper book like the old red schoolhouse, Little House on the Prairie times, when there was one book for all the classes. So you won't expand your knowledge, and you won't talk to any kids. You'll have no social time, zero, because you chose it. And you're going down that pathway again. You got kicked out of basis. You're lucky we left, because you weren't going to be let back. So are you going to do that here too?
No.
You're acting like an asshole here. This is asshole. This is jerk. But you're a big tough guy. You go up by the police. You're going to lie to the police. Tell some guy you're Richard. So I'm going to talk real frank to you. This language is not used out there in front of the baby and the girls. But you're a tough guy, right? You're going to break shit. Let me break shit. Right? I don't give a shit. Let's break it. Let's break all this shit. I don't need it. Let's rip it off the wall. So let's talk tough guy, huh? Let's talk. Let's get real here. I don't need the shit, though. I got stuff that I got to do in my life to pay for your food and your housing and your clothes and your sisters and your brother, that I don't need your extra bullshit that you're just asking for attention for. When you got a lot of gifts that you have that other people don't have, and you piss on them. And you're mad because Baba thinks I'm doing something. Hell yes! Because you do this shit a bunch of times. That's why. And I don't have time to track it all because I expect you to get better. But you don't. You do the same shit over and over and over and over and over again. It's like a 2-year-old. That's why I say, for example, anger. Look at your little brother. He's a 2-year-old. And he got in trouble, he got angry, and he got over it. Nice lesson to learn. Your sisters have devices. Do you think we look at their devices?
Yeah.
You know, yeah, because Mama just told you to make sure they're safe and they're doing the right thing. So you're not fucking special that we're only looking at your stuff. So get off of your own ego, thinking, oh, we're looking at your stuff. You've proven yourself to do bad, stupid shit. Really most stupid shit. Ridiculous stuff. I'm Richard. I'm Richard? Is that what you say you were?
Yeah.
I'm Richard. I'm a tutor, all this stuff. It's what is that? Is that another personality, or are you just trying to lie all the time?
Something not smart.
What?
Something not smart.
Just say it's you're just trying. You're just trying to lie and get through, like what's the point of all that stuff? What?
I don't know.
You don't know. Give me a break. I don't have time for this shit. Like I told you, I gotta try to go and feed the family. If you're gonna break your own shit, that's fine. You obviously don't care about it. So, I don't know why we even give it back to you, give you a chance. So who gives a shit? Why don't you write this down? Huh? Who gives a shit about this? I mean, it's only something I brought, probably back, right? Europe, but you can just throw it away because you can tear everything else up, right? So there goes that, right? Who gives a shit, right? Who gives a shit? I don't care. Pick up that. Why do you have that in your bed?
What's the pretzel?
What? Why is a pretzel in your bed?
You had some.
From where?
Lunch.
Why is it still in your bed?
Because I had a few of them.
Eat it. Where's the rest of them?
I ate all of them.
Eat that one too. Eat it.
Right now.
Right now. You want rats in here too?
No.
Then eat the fucking food. You're gonna kind of stake it in here, and you don't need dinner. You give mom an attitude. You might rattle her a little bit because she's cares and she tries to give you the love, but you don't fucking fool me. You think you're a badass and you're smart. You've done this shit. I've done all the shit you're doing before you were born. You can't mess and fool me. All right? But I did learn. And I changed. If you don't learn and change, not so smart. You say you're smart, but you don't change. You just break your own shit. You rip your own stuff down. Who does it hurt? Not me. You know that. You know the answer to this. So why would you that to hurt yourself? That's just stupid. Why do you say you're so smart but you do stupid shit? Why? And then you say, I don't know. Smart people don't say, I don't know. Let's go. Eat it. Give me that water. Let's go. Go to the bathroom. to the next step. So if you don't give a shit and you want to run away, see how that takes you. I'm not chasing you this time. See how it goes. If you want, should I put this ankle thing back on you? Because I kind of need to know where you're at, just so you don't, hurt yourself. Because you have no fucking idea what's out there. You think you do. All 14-year-olds, 15-year-olds, these kids you're around, you might think you know what's going on in the world, but you don't quite know. Give it a try. Go ahead. But I gotta put the ankle bracelet on you. Because I'm responsible, and when I say I'm not giving up, I'm not quitting, you got me forever, so deal with that. But if you want to go throw your shit away, if you want to ruin your life, if you want to destroy this shit, I'm not going through this again and again and again. I don't have time for this shit. I got to deal with Nola.
Now publishing January 12th, 2022.
It's not on the Chromebook. Okay, what else do you have then? What else is on the Chromebook? Okay, go to the bathroom. Let's get your planner out and you can show me what it says. So this is how we keep in our nice room that we just did? Oh, maybe I can get your Chromebook. You're closed for today. Eating your breakfast, making your lunch. Wait, so one thing you could do is be kind. Just one thing. Now look at anger is just eating you up. Nobody else in this entire house, you. It's soaking into you. We're still trying to be nice. Fiona's still trying to say good morning. I'm still trying to make you breakfast. I'm trying to get you up to see if maybe we can get your stuff done. Right? I'm just trying to help you, Ryan. Make your bed, get dressed, get your breakfast. password to get in here. What is it? What is it? Say the whole thing. 1781. Okay, what do you have to do? So you have to do IXL? I give you a chance to do IXL. I want you to sit right here at the end of your bed and do it. Right here. Facing this way. So it's right here. Just like that. Sit right there. Got it? I'm going to give you a chance to do it. Question is, can you do it? Okay. So you have to do it for math, right? Okay. What are you trying to do right now?
Log in.
So it's still not letting you? If it's not letting you, then just close the Chromebook and put it to the side, because that's what you had to do, right?
Yeah.
Okay. There's nothing else you had to do?
And the other stuff.
What's the other stuff?
On the Chromebook. I can't log in now.
So you can't log into the whole Chromebook, or you can't log into IXL?
I can't log into the Chromebook.
Okay, so then just shut it, put it on your desk over there. I'll grab it in a minute.
Okay.
Here it is. Just shut it. There you go. Lay back down. We're going to read. off the paint? Off the wall too?
I don't think the wall's painted, it's just drywall.
But took that off?
Yeah.
What's going on here? There's like a big cloud or something. What was that? When I just opened this up.
Thank you.
What was that?
The cloud?
It was like either like steam or dust or something.
Does it feel like humidity? I don't know what it was. But thank you.
You're done with your homework that you have to do now?
Yeah.
What's the other stuff you have to do?
I excel.
That's it? I'm gonna start throwing all the stuff in the garbage.
Okay.
All ripped out and stuff, and it's just like garbage pieces like everywhere.
Let's go, get up, shower. Let's go. Piss in your bucket?
No.
Now publishing January 13th, 2022.
Morning.
Good morning.
Alright, let's go grab some clothes, put them in your room. Feel better today? Not really? You feeling happier? Not really. Okay, so you're in the background. Okay. So you got food? I give you water. So just throw the garbage in that garbage bag. I give you these white pieces. Okay, and you can eat. And then we'll make your bed.
Alright.
I can write. That way I can check this out.
Yeah.
Cleaned it up? Okay, sit right here. Right there. These are dirty?
Yeah.
You didn't IXL, right?
Yeah.
Alright, ready? What do you got right now, percentage?
I 76 after the 80.
Okay. Alright, I'll come back in a minute then. You can just brush your teeth. You have socks?
No.
Your socks. Okay.
but then I'll win.
Oh my gosh, you are such a jerk. Like, I really can't get over it. Lay down, I'm taking it. Are you getting rid of your attitude, or are you still gonna keep it? Why do you keep having it?
I don't know.
What's this?
That's something for the jackets that I have.
Where's your pajamas? Get your pajamas. Did you bring this to school?
No.
Why are you staring over here?
You know, I can show you which one is warm to, but it's not great off.
Do you have a reason for all these attitudes every day?
No.
No, you just want to have an attitude, so you just want to stay in here and not, like, have fun with people. Thank you, huh? Not even grateful at anything for someone that just does everything for you?
Thank you.
Should be on your own, grown up.
Why have you been out of your bed?
I don't know.
What are you trying to do?
Nothing.
Did you turn the air on in your room?
Yes.
Are you supposed to touch that?
Did you hear Baba?
Yes.
Did you hear his question?
No.
Are you supposed to touch air conditioning?
No.
Why did you touch it?
It was getting hot.
I don't give a shit if it's getting hot. You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
Glass? Is that what you're doing?
No.
That's what you're doing. Glass all over, right? Right?
Yeah.
So that's what you're doing? You're deciding you're going to break glass now?
No.
Why is there glass broken all over here? What?
I'm going to put the picture frame down and then Baba stepped on it.
No, you were just over here. You're just over here. Why? It's called go to sleep. It's called let's be a happy, nice kid, and you could actually enjoy like your sister's birthday and enjoy time with your family. But then when you're in here, you can just sit and go to sleep and realize that you had a great day. Keep choosing to have bad attitudes and be angry all the time.
All right, Ms. Black, can you put that on pause? We're going to take a 10-minute break. Let's finish this and then we'll take a break. That'll be fine. All right, ladies and gentlemen, we're going to take a 15-minute mid-morning break. Mark, you may escort the jurors to the jury room. And let me have counsel approach, please. All right, court is in recess. All right, everyone may be seated.
Your Honor, there's a minor issue, and I'm asking for just a few additional minutes.
No, you can work it out during another break. I have some stuff I need to address on the court, and I want to get this jury back in here.
So the issue is discovery related as to the videos, and we're trying to cross-reference the.
We're in the middle of trial. Both sides should know what's been provided and what's been received. And unless you're able to tell me that you know right now that something wasn't provided, I'm going to move on with the conduct of this trial. I won't.
There's 21,000 videos, and the state provided me what they're playing, which amounts to 5 hours, which is fine, 7 o'clock the night before, which is fine. I understand that we're all trying to rush and get it done, but we're all only one person. So, yes, there might have been things that were missed.
I understand, but we're in the middle of trial, and trial is not the time to be preparing or making sure you have what you have. You either have it or you don't at this point. If you're able to tell me that there's discovery and videos that have been shown that have not ever been provided to the defense in discovery, I'll listen to you. But until you're able to tell me that, I'm not going to delay the proceedings. That's really.
I don't want to make that representation to the court.
All right. So when you're ready to make that representation, I'll give you all the hearing time that you need when you're ready to make that representation. But what I'm not going to do is, in the middle of trial, give you additional time to determine whether you've had discovery provided to you or not. That's not what a trial is for, and that's not what the utilization of trial time is going to be used by me for, because we have a jury waiting. Where's your client and Mr.
Working on this issue.
All right, they need to come on in. We're going to get started. All right, Dana, I'll deal with the issue you raised with me as soon as everybody's
Sure.
in.
Thank you so much.
No, it's denied. You can do it during a break. All right. As I said, Ms. Marabi, while Mr. Wahid was out, when you're at the point where you can tell me if you're able to make a representation that there was discovery not provided to you, I will listen to you, but I'm not going to provide additional time during this proceeding for you to investigate and make any determination as to whether the discovery was provided or not. So you'll need to, once you reach that decision, let me know, and then I'll give you your hearing time. Before we get started, I do want to note on the record that a request has been made of the media. Everyone can be seated, by the way. A request has been made of the media to review the evidence in this case during lunch. And the court's response is that the evidence and the exhibits and the videos and all of that is to remain in this courtroom during the entirety of this proceedings, and there is no procedure for checking out evidence. However, if the media, or quite frankly any member of the public, wants to make a proper public records request, they can do so with the clerk, and the clerk will follow the law in doing whatever it's reasonably required to do to respond to public records request in a timely fashion. I will say that we're in the middle of a trial, obviously, so the clerk's ability to quickly and immediately respond to a public records request may be in some part impeded by the court's requirement that any public records request not disrupt the orderly administration of justice and the conduct of this trial, which I will not permit. No one, including the media, is entitled to any special privileges in that regard. But if the clerk is able to respond timely to a public records request and also comply with the court's requirement that all evidence remain in the courtroom during the conduct of the trial, then the clerk can leave it to its own devices as to how they provide a copy of any of the evidence that's been submitted. None of the evidence that's been submitted, to my knowledge, in this case is under seal or anything like that, so there's no requirement or prohibition against access to it. It is available as long as the proper channels are utilized in doing the public records request. So that's the court's position on that. So Dana, no one can come up to you during the proceedings except the attorneys and ask to review the evidence. However, if a public records request is made through the clerk's office and during periods of time when this trial is not in process, the clerk wants to respond to a public records request, it's free to do so, and that will be the conduit for which not only the media but any outside parties who request copies of any documents or exhibits that have been introduced into this trial as evidence can receive them. So any questions from any of the attorneys with respect to the court's response to that inquiry from the media? Defense? Okay. All right. Are you ready to proceed with continued publication of the state's evidence? Yes, Your Honor. Okay. You may go ahead and have the jurors brought out. All rise.
Jury entering.
All right, everyone may be seated. Ms. Copeland, Ms. Black, you may continue with your publication of the evidence.
We are still publishing State's Exhibit 17, and we are on January 14th, 2022.
Great. Let's do it. What do we gotta do? How much work do you have? Alright, want to grab some clothes? Put your stuff down for the day. Put a bunch of new ones on there.
all that glass? Yeah, what were you doing with it? Nothing. Get your shoes on. Lying. That's that nice award you got. You got all mad, you broke the glass, huh? Right? Yes? Admit what you do. Let's go. We're not done out here. You gotta get all that stuff out. Garbage is coming out. Talk, so. How'd it go? How'd it go not want to talk to anyone or be a part of the family and just deal with your own stuff? Good? Yeah. Law&Crime handbooks? Ah, let's go. That's nice. Let's go. Do you piss in a bucket?
No.
Let's go. Go to the bathroom. Don't touch the air conditioning, okay? You have to say that again and again and again and again. Don't ever touch it.
Now publishing January 15th, 2022.
Let's go. Get up. Is it dirty?
Yeah.
Let's go. Good job. When's peeing it?
Last night.
What time?
I don't know.
You don't know?
No.
Like when you first fell asleep or just this morning? When? So you don't have to go to the bathroom right now. Put it down. Get dressed. Hmm?
No, I feel like it.
Right? I don't care. Put your shoes on. Go pick your bucket out here. Neighbors don't need to see a piss bucket.
Done, right? Here, take your food.
Thank you.
Is this dirty? Am I just sitting?
It's clean.
Now publishing January 16th, 2022.
Get your clothes for church. I want you to go to the bathroom. Go to the bathroom first, and I get your clothes for church. Let's go to the bathroom.
Clean bucket? Yeah.
short. These are short stories.
Any of them good?
Some of them, yeah.
All right, let me do some yard work.
Alright.
Food.
What'd you say happened with that bike? Remember you told me what happened with that bike?
Yeah, I think it popped off when we were doing moving things from the pot.
Did you say Baba saw that? Did you know it? That's what you need, right?
I already did it. I don't know why I have 2 copies of that.
So you don't need those?
No.
You have pencils, right?
Yeah.
Okay. Where are you going?
I don't know.
What are you doing?
Nothing.
Okay, say your prayers. Let's go take a shower. Is it clean? Drink bucket clean?
Yes.
Now publishing January 17th, 2022.
Wherever you need to go in, I'm looking at that.
Well, I can do more. I just have to read that letter.
What's the deal?
I'm your tech team.
Now publishing January 18th, 2022.
Morning. Let's get to go to the bathroom. Okay, go ahead to the bathroom. Another day of lunch? There, no, let the fish in. Just make sure it's full. So that it's easy to grab stuff that you're, and you can never find anything. There's like, you have no, right, you have 3 spots here, and you can never find anything. So organize it nice, so that it's easy to grab stuff that you use all the time, right? Yeah.
Get up.
I have a mock trial today, serving as prosecutor.
Okay. You need a tie?
Yeah. This one It doesn't fully go around. I mean, you probably need one that goes around to look nice.
Alright, let's take out the garbage first. Take that out. Come on, buddy, want help? Yeah, hold on, I'll let you.
Done?
Yeah.
Okay, close it up, get your stuff you need for school. You don't have any books or anything?
No. You should.
Turn off the light, brush your teeth really quick.
Anything in here that I should be concerned about?
No.
All you need?
Yeah.
Do you have your, the charger for your Chromebook?
No.
Where is it? I had it there to charge it, Mom, this morning.
Yeah. I didn't touch it.
Hmm. You didn't take the charger?
No.
Did you have it all today, like, to charge it?
Yeah. Well, I charged mine in the morning when you gave it to me. I charged mine at school a little.
So you took it this morning?
No. I didn't take it.
How'd you get it to charge at school?
They have some chargers in the room.
Okay. I didn't give it to you to charge. I had it charged over there.
Yeah.
What do you mean I gave it to you to charge?
No, they have some chargers in the room at school.
No, you just said to me, I gave it to you to charge. It was right there. Wait. It's not over here, is it?
No.
So you're saying you didn't touch it?
No.
Sleeping?
No.
Alright, some little stuff on here. Done with your homework, right?
Yeah.
What was the homework you had?
So.
What? Hey, you told me other stuff to do, right?
Yeah.
What?
Yeah.
What was it they had to do?
I finished all my math classes. And then
What math?
I did my English.
What math?
Math in here. I finished it.
This is out here.
It was the math in there.
Yeah, I just moved it. It was out here. You say, what was the homework you were just doing?
I gotta finish English.
With what?
With the stuff that I had.
With what? You weren't doing anything. You were playing with a calculator. So you're just totally lying?
No.
You just totally lied. Okay, go to bed. Did you read some of this book? Oh, okay. Yeah, let's do this again. This worked for you. You can't talk because you just lied and you get caught. Okay. Yeah, that's a good solution. We'll go with that.
Go back to. Where's the charger for the Chromebook? I didn't ask if you had it. What did I ask you?
The Chromebook for the charger?
Yeah. I didn't ask if you had it. I said, where is it?
I didn't take it. I don't know where it is.
I didn't ask if you took it. Go to the bathroom.
Now publishing January 19th, 2022.
Okay. Go to the bathroom, come back, get your clothes.
He's already chosen us not to do that.
Why? Why did you do that? Why did you choose to not have a good day? Doesn't seem right, does it? Okay. Great. You gotta dump your bucket?
Yeah.
Okay. We'll do it. Okay, go ahead. Still get dressed. You got your stuff, right? there? Because they don't know. Look at that book right now.
Okay, can you try to find my calculator? Because I'm not letting that happen again. Because if I don't have a calculator, you fail that class.
Why are you looking at me like you had it, right, this morning?
I didn't have it this morning.
You just said you had it when I just asked you.
I said I had it in my portfolio.
Right, so you had it.
I had it last night, and I put it back in the portfolio when you took.
You kept your portfolio here.
I did not. I remember when you took it outside the room.
Your stuff is now going to be in here when you get at night. Just put it in here in the bin that we're So, quick question, just really quick. Who's Mr. Marshall?
My ISS teacher.
Who is it?
My ISS teacher.
Do you know that teacher?
Yeah.
How do you know that teacher?
You know something?
When?
Is it for hoarding? One day?
You're sent there for what?
Hoarding, for testing.
Okay.
It was last week.
Did you talk to him?
Yeah.
Do you know him?
I don't know.
Like you just know him from in that spot. But you don't talk, you just sit there.
Yeah.
For holding.
Yeah, for hoarding last week. Wednesday.
Is he's a teacher or he's what?
He's some sort of teacher, yeah, I think.
Dirty?
No.
Let's go. What did you put down? Change the go to that. There?
No. Yeah.
Done?
Yeah.
Stand up real quick, I have a question for you. So what class was it recently that you had, they split the class into?
mock trial. So the whole dinner conversation was a lie.
Yeah. So you didn't have more time for it.
Okay, so what happened when the classroom split?
The classroom split?
The two classrooms. The classroom split in two. What happened next?
I went to the other class. I went to the other class.
Okay, what happened in there?
I was doing work.
What work?
For science.
The whole class?
Yeah.
Just doing science work?
Yeah.
Oh, let's go out to kill lunch and get ice cream. Oh, let's go here. Well, let's do this. You have all these things. Right?
Yeah.
And obviously, it's like you don't realize you have some amazing things. And lying gets you nothing. So I don't understand.
Is there some other, like, person in your mind talking to you? So why would you make all that up? Why do all the lies? Who would you steal all these from? School. Well, let's ask the school.
So does Alistair know that you did this to the teacher and his family know this?
Yeah.
So do they know how disrespectful that you are to the school? Do they know that there's this friend, this kid that...
You're just ignoring you. You're not as privileged as people are.
What? Yeah, it's privileged to wear a tie?
No,
You put things in your own head, and when you say it enough to yourself, you believe it. And they're not true. There's no reason. There's no reason.
You're going to go make up a huge mock trial, lie to your family, and lie to the teacher. It's like, what else are you lying about?
Yeah. You're just lying to yourself.
That's the sad thing.
Right? Why are you lying to yourself? You lie to yourself and you think that I wouldn't let you use a
Anything
tie.
under there? You see anything under there?
Is there anything under there?
I ain't even looking at that. Like maybe there was something. So I mean, I can't ask you the truth. So.
It's a double check. So we'll take it away, Ron. This is open. Did you stick anything in there?
I'm scared of me as much as you want. You just, I mean, I keep giving you chances. It's just like lie.
Do I need to rip that apart? You can live in your own lives to yourself. When you tell yourself something enough,
You just lose everybody around you.
Yeah.
You lose the teachers. I don't lose all the, look, the kids find this out with teachers. It's like you want to push
Put it on
people
there.
away.
Yeah. So why would you think I wouldn't let you have a tie again? You're so smart. You get all these stories to tell the teacher that you're in academies and you're there to monitor teachers. Of course I would let you wear a tie. I let you wear a tie for this mock trial.
You need to ask me about putting it on. I mean, it's like,
Put it on. Put that on.
it must, at some point, it's got to eat you up, all these lies. Because you just lied all day. You're out there talking about it, outside saying, talking to your family about it. I have nothing else to say because I don't believe anything. So, are you going to keep that big one or leave it in? Next time, I would give you all these hats.
Yeah, I gave him a lot. I gave him some shirts. I gave him a lot of stuff. He doesn't care about
Give
anything.
him a tie though, and then you give him a bunch of hats, a bunch of shirts, and all this other stuff.
Does it make you feel good to get to this point? Is this what you're always searching for? always like want to get back to this situation?
No.
Because you get here every time.
All right, Ms. Black, we're going to break in 5 minutes for lunch, so just keep that in mind as you play. Yep. All right, so ladies and gentlemen, it's been a long morning for you, so we're going to break a little bit earlier for lunch today at noontime. We'll go from, I'm going to give you an hour and 15 minutes from now. It's approximately noontime now to 1:15. So be out at the elevators at 10 after 1 to meet with Mark, and he'll bring you in here for 1:15 sharp start time. All right, thank you. I won't give you the instruction that you know so well by now. All right, everyone may be seated. All right, anything I need to address before we recess? All right, court will be in recess. Diane, you do not need to stay. You will process any FOIA or public. All right, before we bring the jurors back, a couple things I need to just address. There's been a question raised of the court from the media with respect to the showing of the recordings of the videos that are being played to the jury in evidence. My understanding was that the only thing that was supposed to be blurred out was the minor witnesses when they're on the stand testifying. Does the state take any position with respect to publication or the media showing the videos?
I would want him to be blurred out on the videos, just if his likeness is visible.
And they've been, as far as I know, they haven't even been showing the videos yet, because there was some question on their part as to whether
I think there's some way that they can show. I'm sorry to interrupt.
Yeah, there was some question on their part as to whether they could even show the evidence being presented, and I've never restricted the showing of any of the evidence that's being presented to the jury. The only thing I've done with respect to minors is request that their face or image be blurred out in whatever they're showing. So I don't think there's any restriction. I have not intended to impose a restriction as long as they take measures to protect the identity of the minor, but they otherwise can show the videos and show what's in there as long as the image of the minor is blurred out so that he can't be identified. How about from the defendant's side, any contrary position as to court's understanding of what we've imposed previously with respect to this matter? All right, so for those members of the press that are here and the media, in response to the inquiry that's been made to the court, if you wish or desire to show the videos that are being played to the jury during the trial itself, you're free to do so, but just please take whatever measures or technology you have to blur out the image in any videos that would depict who the minor actually is. So other than that, there's no restriction on showing anything that's put up on the TV or any other evidence that's presented in the case. Okay, anything else that I need to address? I see we're standing. So
no, I'm going to admit a business record into evidence, Your Honor. It states 22. I don't think there's an objection, so I was just going to do that in front of the jury.
Okay, yeah, 22 is your next exhibit number. So while there's a juror eating right now, so I have a little bit of time. While we're doing that, has there been any additional effort on your part, Ms. Murad, to get with Ms. Coakley to deal with the inquiry we had this morning regarding discovery issues?
So Ms. Coakley's providing us.
Mark, let's get them the mic so that she's picked up.
Ms. Coakley is providing us with a copy of the video that she is playing, and the police officer provided us with a video. No, it's on. It's on. Thank you. Do you want to just do it? Okay. All right, thanks.
You're doing fine, so go ahead.
Ms. Coakley's providing me with what she's presenting, and should additional issues come up, we will raise them with the court. I just don't feel comfortable raising that without knowing for sure.
No, I understand, and I'm not comfortable having the jury wait any longer until I know there's actually an issue that I've got to deal with, that I need to put them back there. So that's why I said, work to find out if there's really an issue, and then I'll hear it at the appropriate time if there is one. We're still not certain there's an issue, right? This is the way.
There's just too many videos to be able to find.
That's what I thought. Okay, so all sides ready to proceed at this point?
Can we approach briefly, Judge?
Sure. Yeah. All right, so Ms. Coakley, Ms. Black, is the state ready to continue with publishing? Mark, can you see if our juror is ready yet? My understanding is there was a late delivery of lunch. And Ms. Murad, you'd requested to go only to 5 today, right? Is that still on hold? You still want that if you need the time between 5 and 6 to call your witnesses, if we get to that point? You want to make a game time decision, see where you are closer to 5? So I won't make an announcement yet, because I told them yesterday we'd go to 6, and if that's holds, if anything, we'll end a little bit before that if you tell me you're done. Okay, all right, thank you. We're ready. All right, I'll rise. All right, everyone may be seated. All right, ladies and gentlemen, of the jury, welcome back. I trust that the jury who had to scarf down lunch doesn't get indigestion over the next couple hours. I apologize if you had to eat quickly on that. So in any event, I hope everybody had good lunch. We're ready to proceed with the continuation of the publishing of the state's evidence. And Ms. Coakley, you said you had an additional exhibit to go ahead and admit at this time?
Yes, at this time we move into evidence states 21, which is...
21 is in evidence, so it'd be 22 if that...
22, Your Honor, I'm so sorry.
All right, and has the defense had a chance to look at it? Any objection? No. All right, court receives and accepts State's Exhibit 22 in evidence without objection.
And just for the record, it's independent enrollment record.
Okay. All right. Ms. Black, you're handling the computer play of the exhibit?
Yes, Your Honor.
All right, you may...
Continue with State's Exhibit 17, and we are playing January 20th, 2022.
Okay, you may proceed.
Morning. Did you go to the bathroom?
No.
Okay. What homework do you have to do?
Homework.
Which books to use? Okay. Well, that's good if you don't know, but I'll let you have an opportunity to do so. And it looks like you have some homework. So by saying I don't know, it doesn't really help anybody. So, I'll let you go through this and see if you have some homework you can do. You know you don't know anything.
Dirty bucket? Okay, let's go bathroom. Where's that book from? Okay, keep going.
Who's the teacher that gave you this book?
Carolyn.
And that's English?
Yeah.
Is this something you're doing for class?
No.
So you just gave it to you?
Yeah.
Okay. Alright. Did you get your homework done?
No.
Why?
I didn't have a black pen.
You didn't ask for a black pen. Then you asked. You need a black pen to do your work? You have your work in there?
Yeah.
Did you find?
Thank you.
Here, get your clothes and get dressed while you're out here too. You're gonna find it out there over on the floor by where your old backpack is. You got your stuff?
Yeah.
Go brush your teeth. Get your plate. Get your dirty clothes. Do that. Come on, touch your stuff. Did you have it on yesterday? Did you take it off? Put it. Put your finger in. You probably don't remember. Do you have something in one of these books you can do? Here, Fiona.
Stand up. Why are you giving people shit attitude? Fuck that. Don't say I don't know. Why are you giving a shit attitude?
I'm not thinking.
Fuck that! Why are you giving a shit attitude? Answer me! Before I get really fucking pissed off, answer me. Why are you giving her a shit attitude? We have your school today talking to your people to give you a better opportunity, and you got a fucking shit attitude? Now you got a shit attitude out of me, and it's going to get to the next level. Why are you giving her a shit attitude? Fuck that! Stupid answer. You meant it. For sure you meant it. Why give her a shit attitude? You're goddamn right you're not being respectful. It's fucking unacceptable. You want to take this to the next level? You want to lose all of your opportunities? Those people think that you're talented and you can do well, and you can. But your fucking attitude is going to take your ass down. You're damn right it is. You lie to a teacher, give her some bullshit like I'm going to be an administrator, I'm observing you. Give me a fucking break. I've seen that shit before from you. You don't give shit attitude to your mother, though. I'm not going to accept that shit in this house. If you're going to fuck your life up like we talked about, you can. If you're going to have a good life, you can. But you can play the game with everybody at school like you're going to be smart and all this stuff. I don't give a shit how smart you might be. If you're an asshole, if you're being a jerk, no one cares how smart you are. No one gives a shit. You'll sit in the dark in some spot that no one will want to deal with you. So you change that fucking attitude, or you dive deeper. Which do you want? Yeah, sure. You say you change it, you say you're sorry. A couple days later, all that bullshit that I see goes back to this nonsense. Joke, right? It's a fucking joke. Give you an opportunity. How was the rest of your day?
Okay.
It was okay? Will you come back and give her a shit attitude? Still choosing shit attitude?
Yeah.
Okay, you got homework?
Yeah.
What do you got?
English and math.
That's these two? Huh?
No.
Here we need. You piss in the bucket? What's up with this stuff up out here? Oh, you broke that. What was the glass you broke then? Is it? Look, I'm going to give you a chair. Wow. You're welcome.
you hear me coming? Did you prepare? Now, what are you doing on here so much? Trying to reprogram it? Like, what are you trying to reprogram? You told me, like, last week that you were trying to reprogram stuff. What are you trying to reprogram?
Just graphing.
The graphing?
Yeah.
Alright. You gonna go to the bathroom?
No.
Okay, don't pee in your bucket. You gonna eat the dinner?
Yeah.
Alright. You gonna change your attitude?
Yeah.
It's only gonna help you. And it's annoying to us. It sucks. Right? But it's gonna help you more. So change your shit attitude, right?
Yeah.
Eat your food.
Thank you.
Did you go in there?
Yeah.
Where'd you go?
While ago.
What? I thought I asked you if you could go. You said no.
Yeah, I went before that when you said that.
I don't want you to go in there. I want you to hold it or call for us. Get it. Now we're gonna clear that bucket. I don't need the neighbors seeing. Let's go for your shower. You be the best athlete, you be the worst athlete. You be the smartest person, the dumbest person. The thing that kills it all is being a jerk. It's easy to not be a jerk. You control that. When you wake up and say, I'm going to have a bad day. No, you're choosing to be a jerk. And here's the tool. You ready for the tool? Like a screwdriver to take the screw out? The tool is this. Continually think about things you're grateful for. Here's one. You have a school that thinks you have opportunity. Think about that. You can't be angry and happy at the same time. Angry and happy at the same time. Do you hear me?
Yeah.
Can't be what?
Angry and happy at the same time.
Yeah. So if you are angry, now if you think you're strong and you're mentally smart, well then control your thoughts. Challenge yourself for one day. When you get angry, get frustrated, see if you can beat that, because your emotional self is different than your intellectual self. Those are two different people. And if you let the emotion... Understand?
Yeah.
You have more work to do?
Yeah.
Keep doing it. What's going on now? What are you reading? What is this book anyway? Where did you get it from?
Teacher in English.
Why did you get it from him?
They were supposed to have a book for you.
Weren't you reading Anne Frank?
Yeah, it's like, it's like a literary book where there's a bunch of stories in it.
Yeah?
Yeah.
This is a good book?
Yeah.
What's it about?
It's about a kid, named Michael, who is in...
Who what?
A kid named Michael.
Yeah, what's he doing?
He is trying to avoid bad people.
Yeah.
And he is a Catholic and he befriends a...
Befriends?
Yeah.
Do what?
A Jewish man.
Is he a Catholic altar boy?
Yeah.
Yeah?
Yeah.
I've heard about this book. It's like you. You're a Catholic altar boy. And he befriends a Jewish man?
Yeah.
Okay, what happens next?
His friends... the city is mostly anti-Semitic.
The city is New York?
Yes.
Yeah? What year? 50s?
1947.
Yeah, okay.
The city is mostly anti-Semitic.
What year is 47 after? It's close to what?
1945.
Well, it's close to World War II, the end of World War II, right?
Yeah. That's from Wilfred Owen's Anti-Produced Years.
It's from what?
Those are excerpts from notes for Wilfred Owen's Anti-Produced Years.
Was that the author?
No, it's another book.
Where's that book?
At school. It's with the Anne Frank book.
Anne Frank. So in her home, her dad would call her Annie, right?
Yeah.
And some people call her Annie, but in the American world stage, this is known as Anne Frank. But you can call her either way, just to give you a context. Yeah, go ahead. So what about the world? What?
What?
What's this?
It's Wilfred, excerpts from...
What's in your pants?
Nothing.
No. Excerpts from what?
Wilfred Owen Anti-Produced Years.
Who's Wilfred Owen? Author of what?
Author of a World War I poem.
Poem, okay. Where'd you learn that? In here? In those books I gave you?
At school, because it's we're learning about war material.
Same author from one of these?
Yeah, I think so, yeah.
Yeah. A lot of good authors there. Okay. This is a good book. Who gave you that?
English teacher.
Who's that?
Mr. Fairley.
Is it a nice teacher?
Yeah.
Yeah. Okay. All right, so what else do you have to do tonight?
Nothing else.
So, books like this, we have those books too. This is the kind of stuff. Mr. Fairley is a nice teacher. He gives you an extra book, right?
Yeah.
This is the kind of relationship you can have with your family too. I give Fiona books like this all the time. There's another really good book called author's Carlos Ruiz is from Spain. You lived in Spain. You lived in Barcelona. There was a civil war in Barcelona right around the time of World War II. Did you know that? Why did Spain not get in World War II?
Because they were doing internal problems.
Franco is fighting with his own people, right? Mm-hmm. And he's doing a lot of bad stuff. So there's a war about the fight against Franco and doing the right thing in Barcelona. Shadow of the Wind. You could get more stuff. It's a good book. I think it's a book bestseller, right?
Yeah.
So there's a lot of good books like that. You learn from reading those books, right?
Yeah.
Catholic altar boy aligned with a Jewish. What's the guy's thing? He's
it's a rabbi.
A rabbi. A rabbi is?
Yeah.
What's a rabbi?
Jewish teacher.
Yeah, and they kind of like the priest. Jesus was a rabbi. High rabbi. Jewish rabbi. Right?
Yeah.
Back then. Anything else?
No.
What time is it?
Nothing.
All right, keep reading.
Good night.
Now publishing January 21st, 2022.
Look dirty?
Yeah.
Let's go back to What do you got to do on your Chromebook?
So.
Let's go get dressed for school. Where's your charger? This thing charged?
Yes.
sit where I can see her.
Mom has me go with that.
Why?
Because she hasn't set up big mess.
Why do you need to jump there?
Maybe it's ice out now.
Well, whatever. That's fine. Sit there, but I need to be able to see both.
Okay.
Why don't you make your bed first?
Okay.
Am I aid with you?
Yes.
Go ahead. Go ahead. Go with him. Go ahead. How's it doing?
Good.
I'll let him eat your food.
Yeah, you can. Boy, boy.
Back over. It's still bleeding or just it'll get better blood? I guess it's dried up.
You know why that is?
What?
Do you know why I check that? I understand you get frustrated, but do you understand why?
Because you don't want me to have anything?
Oh yeah, that's the reason. Good, that's a good line, you're right. Let's go with that. You're trying to fool, Lauren, but it's not. Being unkind is not going to get you anything. You're not kind, you're not going to get anything. So I don't know what you're trying or what's going to make the change for you, but I got a bunch of other kids who are. So I don't know what you don't understand about that, but that's the truth.
How's this day?
Good?
Good?
Yeah.
You get in trouble?
No.
Why is that unplugged?
It was unplugged when I came in.
So did you give Vala a better attitude?
Yeah.
Did she put you in here?
Yeah.
Is that dirty?
No.
You want to come out?
Yeah.
What are you reading?
Maybe I already with you.
What's it about?
Oh, it's his artistic life, like the commissions that he did for the kings and stuff.
Hey, come on here. Let's go. Come on. Maybe tomorrow. Maybe tomorrow I'll show you what to do.
in the bucket?
No.
Let's go to the bathroom.
I go to the bathroom.
No. I think so.
Thank you.
Yeah. Go bathroom?
Yeah.
Sure.
The state will now publish January 22nd, 2022.
Morning. Clean?
Yeah.
You gonna be respectful today?
Yeah.
Good. All right, let's go to the bathroom.
Whoa. It's already 8. Why not even go by it?
You ready?
Yeah.
Let's get that. Yeah, let me know what you learn.
Yeah.
How's the book?
You good?
Any good?
Yeah.
So did that battery die when you were cutting?
No, when I was blowing.
So you got it all cut?
Yeah.
Alright, so next time probably could use a lawnmower. Alright.
Here, I got the phone. You're sleeping?
No, I was reading books. Thank you.
Alright, good.
Good night.
Statement out published January 23rd, 2022.
All right, after this one, we'll take a Mid-afternoon break.
Yes, Your Honor, this one is 11 minutes and 32 seconds.
Perfect time.
Morning.
Wait.
To the bathroom. Did you do homework there? Did you send someone there?
No. But
Work? You're gonna make 12 hours breakfast, right?
can I get my calculator?
You what?
Calculator. It's in the portfolio. First pocket.
Actually, I think it's more.
They make it better every day. So what else about that guy?
Oh, he's working as a marijuana runner now.
Did you go to jail?
No.
Change for what?
I don't want to wear this to them. Yeah, but wait a minute.
Hi there, how'd it go? It was good? Yeah. You had fun? Yeah. Are you gonna play outside? Ride your scooter? You ride your scooter out there? So you're just sitting there reading? You're not doing anything else? I have homework to do.
Yeah, but it's coming.
What?
I have to do Excel and reading plus.
So why do you ask to do that?
I do Excel and reading plus.
I'll show you exactly where you have to sit. Sit right there, sit facing. You have IXL?
Mm-hmm.
And what's the other one?
Reading plus.
What teacher is that?
they're in the bin, I think. Women's radio.
Hold on. Nothing in here, right? That
No.
we'll go check it out before we have you just come in here, since you got and all your fun stuff.
Here, Sean. So did you get mad when she checked your pockets?
No.
So don't give her anything on that because you earned that. Okay? It's a nail there. It's in the ground there.
That's a lie down.
Okay, go ahead. Where do you think you're shooting at? Have a fun life, just like your sisters. Okay. All right. You don't need to air on tonight. We can read.
Yeah.
Your Honor, we can take the break now.
Okay, all right. All right, ladies and gentlemen, it's about 2:40. We're going to take a 15-minute break, so just shortly before 3, we'll reconvene. Thank you. All right, everyone can be seated, and the court will be in recess for 15 minutes.
Session, the Honorable Judge Howard Coates presiding.
All right, good afternoon. You may be seated. All right, you ready to continue, Ms. Black? Defense ready? All right, Mark, you may go ahead and bring the jurors out. All rise.
Jury entering.
All right, everyone may be seated. Ms. Black, you may continue with the publishing of the evidence.
We are going to continue publishing State's Exhibit 17. We are on January 24th, 2022.
There's that one?
Yes.
Good?
Yes.
Grab your clothes here. Are you going for school?
Yeah.
Are you still using this belt?
No, I use this one.
Well, so you don't use that one?
No.
Like your bed?
Yeah.
Good socks and everything? Okay. Really neat. Exactly my best.
Yeah. Good.
Good. Here, I'll give you all this because everyone just ate different kinds here. Is that stuff dirty for later?
These are pajamas. These are clean.
Okay. So, when you get done eating, then you have Excel and that's it?
Yeah.
You finished English, you finished everything else. Finished math?
Yeah.
What else did you finish?
Civic.
Finished it all. Okay.
Yeah.
So you just have Excel in here for what? English or
Math.
keep that there when you get done eating.
Thank you, Mom, dinner.
Hopefully tomorrow or the next day we'll all sit and have dinner together. Okay? Why are we playing games?
You're not.
You are. You're not. I'm trying to give you a chance. I'm trying to let you have an opportunity, right? To be honest, to be trustworthy, to do what you're supposed to do, right? Right? You don't want that and you don't want all these things, well then that's fine. But if you want to have all these amazing opportunities and things like that, then at least be honest. Be honest to yourself, be honest to me, and do what you're supposed to do. If every time you have homework on your Chromebook and I give you a chance and you lie about it and you're being sneaky, I'm not going to continue to do it. But I'm giving you a chance. Look at me in the eyes. And you're caught and you're mad. It's the same thing, but a different day. So that's fine. So you can just do your same stuff like every other day. pajamas? Are those them right there? Do you hear me? Oh, here we go. Back to this, Ronan. Where you can't talk, you're a middle school boy, you want to do all these things, you want to do chess, you want to do things, but you can't talk because you got caught being dishonest. Okay, well, that's fine. Guess I'll just keep giving you more chances. Every day, it's a new chance for him. Even though he doesn't care, he doesn't want to be nice to anyone. Let's let me bring him some food because I think he's going to have a good night. Oh, let me do everything for him. Okay. Oh, but I can't talk because he got in trouble because he got caught. It's like, give me a break. Start owning up to what you're doing and then try to fix the problem like we keep telling you.
Now publishing January 25th, 2022.
It's a new day, right? Right? New day. You mad at yourself because you get caught? You get done with it. Move on with your day. You have another good day. I'm just trying to give you what's better for you, right? Clothes. There's some breakfast. Are those dirty? What? Are they dirty or not? They're what? I know, you didn't wear them. Are they dirty or they're clean? Now let's come back over here. Grab clothes.
Now publishing January 26th, 2022.
And then you can divide Excel, right? Yeah. So you got the other checks to do.
Cheers. Let's go. No, I'm checked out.
Okay, you get over here. Okay, I'm going to give you those. Actually working on it?
Yeah.
Okay. Are you searching up other stuff while you're supposed to be doing this?
No.
Okay. This is going to be it. I'm going to come get it right before we go. Is that the only one you have to do?
I have to do a couple more after this.
Can I do a couple more?
Okay, what percentage?
78.
Alright, is it tough one?
No.
Alright, I'm going to plate. How are we doing? Make the bed?
No.
Clean up your room? No?
I clean up okay.
Make sure the looks nice, get all your stuff together. And we'll brush your teeth, then I'll have the dog come right at you. Go.
Alright.
Here, wait, no. go. Let's go. You know the girls.
They're good because, as a cover-up, they said the person is taking diagnostics.
Yeah.
Because it's a cover-up because they don't want to embarrass the
It doesn't
person.
matter, yeah. It doesn't matter. Everybody's probably gonna. You could be out. Like if we decided, we could say you're not going back to school.
Yeah.
So like there could be a lot of people now being out.
All right.
So hey, don't put your dirty stuff all. No. How's it going?
Good. All right, thank you.
Spoon, soup, and
Okay, thank you. Yes.
all right.
Okay, good night.
Good sleep. Good night.
Now publishing January 27th, 2022.
Morning.
Good sleep?
I slept okay.
Yeah. Want to go to the bathroom?
Yeah.
Let's clean your bucket out. Let's put these in here. So you should be together like that.
Yeah.
Did you You done?
Yeah, I'm just doing it. I'm doing editing class for English.
Okay, ready?
Yeah.
Get your stuff.
No.
You need to make your bed in the morning, okay? Because you got plenty of time, right?
Yeah.
Do your homework done?
Not yet.
Kidnap Publishing, January 28th, 2022.
Renee, we should go to the bathroom. Do you need to take a shower today, or you can do it tonight?
I can do it tonight.
Okay, let's go to the bathroom. So you do it, can you make your bed first?
Yeah.
Clean up like your space here?
Yeah.
You don't have too much that's cleaned up, right? So if you make it look nice, it's a good thing, right?
Yeah.
You have a good day?
Yeah.
Friday, right?
Yeah.
Having fun on Fridays?
PE in the morning. For last time until another 6 weeks, because it rotates every week.
Okay. Okay, so what are you working on right now? Because you said you were finishing the IXL, right?
Yeah.
Okay, so what are you working on right now?
Seeing if it shows up.
What?
Seeing if it shows up.
You're doing IXL or you're not?
I am.
So what percentage are you on then?
46.
gone.
Bad.
Why?
The problems are not. I don't know.
Almost done. 66, right?
Yeah.
Is it dirty?
Yeah.
Alright. Why don't you grab your clothes really quick so that you have them on? What's wrong with the problem?
Nothing wrong with this. Hard to go through.
So you're done now, right?
Yeah, no thanks. Sorry. Less.
Okay, how much do you have of that?
I have 2 vocabularies.
Okay, I'm gonna come in and grab that in a couple minutes and have you get some of those shells.
Okay.
Okay. Okay. Alright, why don't you leave the stuff in here? I'm gonna have you your shoes.
No.
Your shoes are right there.
Oh, yeah, I need to change my shirt because I brought this morning.
Can you tuck them in?
No, it's not gonna be big enough.
Okay. So.
This is Mega Pony room.
Mega pony room.
Mega Pony room. Yeah.
For real, that blue bucket.
Let's go.
Okay.
Maybe later you can see my class. Yeah, I'm trying to. Maybe you can see my class later.
All right, thank you. Does the state have any additional items to publish?
We don't, Your Honor. At this time, the state would rest its case.
Okay, ladies and gentlemen, that concludes the state's portion of the case. The state has rested. There are some things that the court needs to address outside of the presence of the jury. So, Mark, if you could escort the jurors into the jury room, and I'll let you know when we're ready for you. All right, everyone may be seated. Does the defense have any motions?
Judge, at this time, we're going to move for our first judgment of acquittal. Essentially, obviously there's 3 counts here. The aggravated child abuse count has 5 different ways that it can be proven by the state. Either aggravated battery, willful torture, maliciously punished, willfully or unlawfully caged, finally knowingly, willfully committed child abuse, and in doing so caused great bodily harm, disfigurement, or permanent disfigurement. The state in this case, I think, has failed to prove that Mr. Ferriter willfully, intentionally inflicted any physical, mental injury that resulted in great bodily harm. The terms great bodily harm, permanent disfigurement, these come from the aggravated battery statute. There has been, as far as I can recall, no testimony that the child suffered great bodily harm, which means distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises, which were also not presented. Likewise, there's no testimony that this child was in any way disfigured. Aggravated child abuse is committed through other ways as well, of course. Malicious punishment is reserved for certain types of cases. In Florida, Wheeler v. State controls in this district. It's 203 Southern 3rd 1007. In that case, the rule that comes from that case is that great bodily harm or permanent disabilities or disfigurements are what demonstrate actual malice on the part of a parent and not merely a momentary anger or frustration. So the state, I think, has failed to prove actual malice. Malicious, there's a definition for malicious in the jury instructions. Wrongfully, intentionally, without legal justification or excuse. Maliciousness can be established through circumstances, and one could conclude that a reasonable parent could have engaged or not engaged in that conduct, depending on those circumstances.
But in a motion for JOA at this stage, doesn't the state get the benefit of all favorable inferences? And so if I were to buy your argument there, at this stage, I would have to conclude that they have established malice.
Well, I do think that I think actual malice, though, under Wheeler, is that it's not any sort of a momentary anger or frustration. It's discipline that results in great bodily or permanent disabilities or disfigurements, or demonstrates that the actual malice on the part of the parent was not momentary anger or frustration. So I don't know that we have any evidence of that. I haven't seen any evidence of that. What the state is essentially relying upon, factually, from that perspective, is moments where he comes in, he's yelling at, and those interactions that we saw this afternoon on the video, those fit more frustration and anger, if anything, but not great bodily harm.
But we're talking about malice, and we're talking about intent, right? I mean, that's the purpose that you're making this argument at this stage, right?
No, well, I'm going under the 5 ways to prove child abuse. Of them, I'm going through them. So I'm saying it's not aggravated battery. I'm saying it's not malicious because we don't have great bodily harm. I also believe it's not torturous. I don't think there's any facts to go to torturous. And I think that the closest call here would be for the state is caged.
So you're trying to convince the court at this point that no jury could ever find that being confined in a 8x8 room or box, however you want to refer to it, that no jury on earth could find that to be torturous? Because I really have to find that no reasonable jury could conclude that that was torturous under the facts that have been presented. Again, which is why at this stage the state gets the benefit of all favorable inferences. Is that the leap you're asking the court to make at this point?
So torture involves extreme or sadistic conduct, which is absent here.
Well, I'm going to push back on that. I don't know that it's absent. What I believe is that there's certainly enough for a jury to determine whether it's torturous, evil, or sadistic. I mean, the video displayed many repetitive instances of the father coming into the room, his son snapping to attention in demonstrable fear, a repetitive, consistent berating of the child. It seems to me, and I'm not judging the facts one way or the other, I'm just merely determining whether they meet the standard at this point so that they can be passed along to the jury to make that determination. And it seems to me that a jury could conclude that this is torturous and that it is something done with evil intent and malice. So move on from that, because you're not going to convince me that no reasonable jury could conclude that this is a torturous event here in the life of this child.
Well, in terms of the other elements, you have the argument was malicious, and in that I want to also draw the court's attention to Wheeler, which I gave the court the cite, but there is a clear difference between a parent's discipline and something that goes beyond and results in great bodily harm to the child. So I don't believe we have that here.
Okay, so let me read to you a provision that comes out of the case of Slocum versus State. That's at 757 Southern 2nd, 1246. And I'm quoting from that case because I think the part that I'm going to read is apropos to this. And just bear with me for just a second, Mr. Wahid, while I get to it. The court said, and this is out of the 4th District Court of Appeal, which is the court that obviously handles direct appeals from this circuit. Regarding another conduct element of aggravated child abuse, the dividing line between permissible punishment and malicious punishment is not always easy to draw. A defendant maliciously punishes a child if the punishment is imposed wrongfully, intentionally, without legal justification or excuse. The element of malice requires evidence that the defendant acted with ill will, hatred, spite, or an evil intent. And then the court cites the Gaylord decision where that court made this statement. The determination that a parent or one standing in the position of a parent has overstepped the bounds of permissible conduct in the discipline of a child presupposes either that the punishment was motivated by malice and not by an educational purpose, and that is, was inflicted upon frivolous pretenses, that it was excessive, cruel, or merciless, or that it has resulted in great bodily harm, permanent disability, or permanent disfigurement. And I think that recognizes that the great bodily harm, permanent disability, or permanent disfigurement is only one aspect of how you get to ultimately a conviction in an aggravated child abuse case. But the point I want to make here, and then I'm going to switch to one other case, and I'll let you have the floor back. And this is the Tate versus State decision, and I'll give you that site. That's at 136 Southern 3rd, 624. And this is what the court said in Tate, which gives me great pause in terms of the motion for judgment of acquittal here, and it says, Tate suggests that the state failed to prove that Tate intentionally abused HR, which is similar to what's being argued here. Because direct evidence of intent is rare, and intent is usually proven through inference, a trial court should rarely, if ever, grant a motion for judgment of acquittal on the issue of intent. And they cite a number of cases holding that intent is rarely susceptible of direct proof and is almost always shown solely by circumstantial evidence. And this picks up with what you said. Where reasonable persons may differ as to the existence of facts tending to prove ultimate facts or inferences to be drawn from the facts, the case should be submitted to the jury. So that's why I asked the question the way I did, is because if you concede that reasonable jurors and reasonable persons can disagree about what they've seen on the videos and what those videos mean, then that presupposes or actually mandates that I deny your motion for judgment of acquittal at this point. Do you at least agree with that argument?
Well, generally, yes. My only pushback on that would be that, unlike, I think, in some of the other cases that you've cited and I've read Tate, just reading the case, what I think is different is here the jury has and the court has not just the video but the audio, and the audio has the words from Mr. Ferriter himself, and you can see and hear in that there isn't it isn't malicious, that in the sense that ill will and no educational purpose. It's quite frankly the exact opposite. What you see and hear is that he's saying to that you did something wrong, and I'm trying to raise you to be somebody who's a good kid, not someone who is out there doing things that aren't good for himself or others, and you're not going to, you're going to go nowhere in life, and I want you to go somewhere in life. And there was some clips shown today where he's actually in the room going over homework with Ronan, and there's a lot of conversation about doing homework, and it's every time you see on the video that there is something that did wrong, whether it was impersonating a teacher at school or lying to somebody or lying to a teacher or those types of things, then the consequence you see on the video is that's when he got something taken away from him or he got in some way punished. And then he acts out again, of course, as a result of that punishment. And it's very sad to see how he reacts to that, of course, but that doesn't change the fact that the jury and the court has the evidence in terms of the audio as to why that conduct happened. It was not for no purpose or malicious purpose. It was for an educational purpose.
All right, so with respect to the aggravated child abuse count, without justification, is it your position that applies to each and all of the different avenues which can be traversed in order to arrive at a conclusion of aggravated child abuse? Because the reason I ask it the way I'm asking it is, a couple of the avenues require great bodily harm, and I do have the question for both sides to address as to what, because there was evidence of mental injury. I don't believe there was any evidence of any great bodily harm. So the question is does any kind of mental injury rise to the level of where under the law it is considered to be great bodily harm? That's the first question. But this is the part of the information in terms of one of the prongs or one of the avenues that I want you to address specifically, and that is willfully tortured, maliciously punished, or willfully and unlawfully caged. And that does not require great bodily harm. And what I've just stated to you are the elements of aggravated child abuse following that avenue. And address that, because it seems to me that on that basis alone I should be denying your motion for a JOA on count one, because there's at least one avenue that jumps out at the court that clearly a jury would be the proper entity to decide the issues in this case because of where the evidence stands at this point.
So interestingly, the jury instructions don't give us a definition of caged and whether it's temporal or not. And two things I would point out factually to the court. One is many, many times when the door closed in the video, you don't hear a lock. So the door isn't locked on many occasions. So Ronan could open the door and walk out, just like anyone can in any room, and therefore those definitely would not fit the term of that level of confinement that one would say would be synonymous with the Webster's dictionary version of caged. There are times where he is, but there's a temporal aspect to that. And we heard it from, I believe it was Officer Lowe.
Let me ask, was there one time in any video that was played by the state where the victim walked out of the room without the parents opening the door first? I don't recall seeing a single instance of where that occurred.
That is true, but that's different because the door not being locked would not, in the terms of confinement under the law, in terms of like other types of cases or kidnapping cases or people being cuffed to things, you know, you can decide not to go out. You can decide not to go out because there might be a consequence to going out and that you get in trouble because you weren't supposed to go out.
But why wouldn't that be a basis for confinement under the law where you have great fear that if you come out, bad things will happen to you? To me, is there anything in the case law that gives guidance on, because I'm not sure I agree with your argument that it wasn't locked, but that would be up for the jury to decide. But the legal point that you're raising for me is whether confinement actually requires a lock or confinement be achieved by virtue of the inducement of fear in the victim. So the victim is scared to death to come out.
So the difference in this particular set of circumstances, and the case law does say, I mean, not on caged per se, but on child abuses, and you just read it, Judge, it's very fact specific. So we're dealing with the facts here, which is parent-child, right? Parent-child in a situation where at times children get punished. If I send my daughter to her room and say, you're confined, you're not going anywhere tonight, you're staying in your room all night, I'll see you in the morning, it's not that she is confined in terms of caged under the law. She's not supposed to come out. Doesn't mean she can't come out. That is not a crime. That is not something where this court would find I committed child abuse. So I think there's a difference because of the circumstances between the two parties here, father-son. And clearly, as you can see in the video, it is every instance is tied to something that has done. He's admitted that on the stand.
But are you making the argument there that just because there might have been a legitimate purpose in the punishment, that a parent can never exceed, going back to the language used in the Tucker case, the Tate case, that where the punishment exceeds the permissible bounds of what is proper? To me, that presupposes there can be a motivation or a legitimate reason that started the punishment per se, but that punishment can go off the rails and exceed what is permissible in any reasonable society. I mean, you're not making that argument, are you?
No.
All right.
Of course, it could. And again, and as the court.
All right, so you just accepted that.
Yes.
So if you accept that, do you not agree then it becomes a jury question as to determine whether the punishment here, the specific punishment, crossed the bounds of what is proper in a society such that it could be aggravated child abuse? Because, I believe there's enough that they could define that the victim was unlawfully caged. And so if you concede that, doesn't it have to go to the jury to decide it?
So again, then we would say in every case that it would go to, every case would then go to the jury because it's a question of do the facts meet the elements, right? And that's what I'm getting at, is that this specific set of facts.
Well, it is that is the question, but it also comes with a big proviso, provided at this stage the state gets the benefit of all favorable inferences. So when you want to refer to that room as a structure, a box, or a cage, they get the inference that, hey, it's a cage, and it demonstrates caging at this point, don't they?
Well, I think caging, so the issue is that since my reading of the jury instructions, that there isn't a definition of the word cage. So, what we're really looking at is, and by all accounts, it's a room, correct? The caging aspect, is my understanding, would be, just from Webster's version, is that it's locked and confined and you can't get out. The only sort of caging case that I think I found in the fourth was Blow versus State. Doesn't really apply because it's handcuffed and chained to something kind of a case. And quite frankly, in that case, they said the district court held that the plain meaning of the term cage does not include the act of chaining or handcuffing, and therefore the state did not present a prima facie case. And that's Blow versus State, 993 Southern 2nd 540. I'm sorry, that's a second DCA case, not a fourth. I didn't find one in the fourth.
Right. So, Mr. Wade, because I do think you might have a meritorious argument that there are some aspects of count one that should be narrowed. And so I want to focus on that because that, to me, is where the real legal issue here is. In all of the avenues that are available for aggravated child abuse under count one, you agree that there are some that do not require great bodily injury, correct? The one I just talked about does not require great bodily injury.
Correct.
All right. So is your motion such that you're moving for a JOA on certain aspects of count one where great bodily injury is a requirement, and in your view, the evidence that's been presented by the state fails to demonstrate great bodily harm? Because if that's your motion, there may be parts that I need to have a conversation with the state about, because I have questions and they will need to explain to me where the evidence is of great bodily harm, if great bodily harm does not include PTSD or any mental injury. And if it doesn't, then there may be a basis to narrow count one.
So would it be both? Obviously, I'm moving for all counts, but as I made the argument, it includes what...
Yeah, you're going to lose on, I'm just going to tell you up front, and you can make your argument for the record, you're going to lose on the willfully tortured, maliciously punished, or willfully or unlawfully caged. I would be denying that because I think it jumps out at me that there's enough evidence for that. But the others, I'm not so sure, which is why I want to focus on that, because that's where the bigger part of my effort needs to be focused on at this point, is if I have to narrow count one.
Fair. So my position on that, and obviously then I'll turn it over to the state, is that great bodily harm and permanent disfigurement, they are defined. Defined as great means great, as distinguished from slight, trivial, minor, or moderate, and as such does not include mere bruises.
But it's got to be bodily harm, right? Yes, physical
bodily
harm to the tissue, to the bones, to the skin, correct, those kinds of things. Mental injury does not fall within that category.
Not on reading of cases that I've been looking at.
Okay, so let me take you to the second avenue. It's kind of in the information as well. I marked it as number 2, the avenue. And that is that the defendant did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury. Now, that standing alone, you would lose, because I think there's evidence of mental injury. But it looks to me like in that particular avenue that it carries with it the conjunction and that it still has to have or result in great bodily harm, permanent disability, or permanent disfigurement. Let me hear your comment on that as well, because I think you're making the argument that it applies, but I want to hear you say it so I can properly register it.
Yeah, it's a conjunctive. It's an and not an or. Yes, I agree with the court on that.
All right. Do you have any case law to where it's been interpreted that way? I mean, I think reading it makes me understand it that way, but it won't be the first time I've read a statute and there is an appellate case out there that interprets it in a way that I might not always have interpreted it. Were any case?
I focused on the fourth, and I used Wheeler versus State. It's a 2016 case, 203 Southern 3rd 1007.
All right, and so the last avenue that's in the information, and that is did commit an aggravated battery upon RTF, a child contrary to Florida statute 827.03. By virtue of the aggravated battery, that presupposes and subsumes great bodily injury, doesn't it?
Yes, Judge.
And so just mental injury would not be enough to sustain that prong. You agree with that?
Yes.
All right. So I'm in agreement with a substantial portion of what your argument here is. I haven't heard the state yet, but I see where you're going with your argument. I've told you that I already disagree with you on the one avenue that talks about willfully tortured, maliciously punished, or willfully and unlawfully caged. Are you going to address count 2 or count 3 at this point, or is your motion only to address count 1?
Count 1, Judge.
Okay. All right, so let me turn it over to the state, and who's going to argue, Ms. Black? All right, so I've given you kind of a roadmap of some of the issues that I've already looked at, and I want you to address, and I saw you shaking your head back there when I was talking about the mental injury. You concede that mental injury does not constitute great bodily harm under the statute?
Yes, under the statute is not. We are not proceeding under 1A or 1E. We are going under the theories of 1B, 1C, and 1D.
Okay, so let me go through the information, and then you can address it. The information says that, Christine and Timothy Ferriter are about December 28, 2021 to January 28, 2022. And I'm going to cut through what I don't have to read. Did knowingly, and this is what I consider the first avenue, did knowingly or willfully intentionally inflict physical or mental injury that resulted in great bodily harm, permanent disability, or permanent disfigurement to RTF a child. Okay. That presupposes the infliction of physical or mental injury. I think you have both of those here. There was physical injury and there was mental injury. The physical injury doesn't necessarily mean great bodily injury, but there was physical injury and there was mental injury based on the evidence that I've received. But that carries with it the additional requirement under that avenue that it has to result in great bodily harm, permanent disability, or permanent disfigurement. So my question to you is the state pursuing a conviction under that prong? All right, so that settles that. The motion for JOA on that prong is granted, so that won't be presented to the jury. So let's go to the second avenue. Did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury? Again, it's just like the first avenue. You've got the physical injury and you've got the mental injury, but you have that little word there, and it says did result in great bodily harm, permanent disability, or permanent disfigurement to RTF. Is the state pursuing a conviction under that avenue?
Can you give me 1 minute, Your Honor?
And you may want to address the word and what you think it means.
Your Honor, it seems like you are going off of the information, the charging document. We're going over the jury instructions as far as each of the elements.
Well, but the information tracks the statute, doesn't it?
Proceeding under that prong, however, as to the great bodily harm, however, the lesser of child abuse includes the portion of that without great bodily harm.
Without great, so
you would be asking going forward on that.
Right, right. I'm only dealing with the top level offense, and I'm ruling the way I am because of the absence of great bodily harm, but that does not negate the lesser included offense of child abuse, which doesn't require great bodily harm. So let me be clear on that. So based on that, deal with the and did result. Do you agree with at least the court's initial interpretation of that and Mr. Wahid's conclusion as well, that in that avenue it requires that there also be great bodily injury?
Yes, if it says and, then it.
All right, so you're not pursuing that based on the evidence that the court received thus far. And then the third avenue, I've already ruled in your favor on that: willfully tortured, maliciously punished, or willfully and unlawfully caged, RTF a child. That one you are pursuing, and I would think that that's the major brunt of the state's case in regard to count one. Am I correct on that?
Yes, Your Honor. And just to kind of address what defense said in their argument as far as Blow versus State, in that case, it did not. They said that caging does not include chaining a child, but they did talk about how the caging aspect is a wire or bar box-like structure or a small restrictive.
Yeah, you don't need to spend any real time on that because I've sat through the hours of video as well. It can be up to these folks to determine if that's a cage or not. What I'm concluding is there's enough evidence for them to determine that it could be, so it's going to be up to them. And then the last one, which I consider to be the fourth avenue, is did commit an aggravated battery upon RTF. Do you agree that that presupposes great bodily harm, so you would not be pursuing the charges or a conviction under that avenue?
Correct. Okay,
so here's where we are with what will be presented to the jury if we get there after the presentation of the defense case in this matter. So count one, the motion for JOA is granted as to count one with respect to everything except the requirements in the avenue of willfully tortured, maliciously punished, or willfully and unlawfully caged, which, based on the court's conclusions, as to the evidence up to this point, that would be presented to the jury to determine. That does not mean that the lesser included offense of child abuse will not be presented, because it will, because that does not include the element of great bodily harm, which is the primary impetus behind my rulings in narrowing down count 1. So everybody with me on my rulings on count 1? So I think I've covered everything I need to cover in terms of my rulings. Is there anything else, Mr. Waheed, that you would need me to address from the standpoint of your motion for JOA? Okay. Any clarification? Okay. All right. And the court will reiterate and reconfirm its prior rulings in regard to all of the motions and objections that Mr. Waheed and the defense have made during this proceeding. If that's what we're just renewing all of that so that they're the same ruling as before. Ms. Black, anything that you ask or need clarification from the court on as far as my ruling?
No, Your Honor.
Okay. All right. So at this time, Mr. Waheed, it's appropriate for me to ask before I bring the jury out is, do you intend to put on a defense? Yes, sir. All right. And have you made a decision at this stage as to whether your client intends to testify so that I can conduct the necessary colloquy? All right, so you want to do those witnesses before you make a decision as to whether your client will testify or not? Okay, all right, so that just means that I'll defer the colloquy for you, Mr. Ferriter, until such time as we're at that point where you have to make a decision whether you're going to testify or not in your own behalf. You understand all that, sir? Okay, good. All right, so Mr. Waheed, I don't see Ms. Murad. You want to take a 10-minute recess before we start? All right, so we're going to be in recess for 10 minutes.
And Your Honor, to remind you, I renewed my objection to, in light of the testimony to Kellen McCoy, who is the teacher, about the incident where he embarrassed his sister, as that is not an issue in dispute. It was disclosed by the child during his testimony, he fully admitted to it, and to have an additional witness testify to the same event that is not in dispute would be cumulative, especially when it's a prior bad act of the victim.
Mr. Waheed, do you want to address that, or is that for Ms. Murad? No, I can. Let's get you mic'd up over there. You're good.
Yes. So that incident results in a response from Ferriters, which goes to part of our case, which is that they engaged the school. They took the time to listen and understand what happened and gather all the facts before doing any sort of response to. So going through that process that the Ferriters went through goes to all of what we're saying, that their conduct is not malicious, that it is educational, that it is parental, and it drives directly to a parental defense.
Is she going to testify to anything else other than what was admitted by the victim on the stand?
Yes, she's going to testify to the fact that the Ferriters engaged with her in the school and exactly what I just said.
And she's a teacher?
She's a teacher.
And Your Honor, if you'll recall, the child testified to those specifics, that there was a meeting, that his mom had a meeting, and that his dad came, and that he went into the room with the teacher with the dad. All of the facts in which he's going to elicit have already been elicited without dispute.
Yeah, I'm going to deny the motion. I think the defense is entitled to call the witness because she may have a flavor that the victim himself didn't present, and so you're entitled to present your defense, and I'm going to allow that witness to testify. Consistent with the scope and the parameters that I've already set out many times already with my in limine rulings.
Understood.
Okay. All right. Can you let the jury know it'll be 10 minutes, and then we'll start back up with the defense case. All right. Court's on recess for 10 minutes.
Before we start the defense, please, I emailed Your Honor's judicial assistant about the 2 witnesses that will testify by Zoom. We're going to do them first, so if you could just make sure they're there.
Let me pull up my email here.
Thank you. I emailed Ms. White directly, so it may not be there.
Well, she would send it to me, so let me just see if I've got it here. You sent it to division. So, ladies Ladies and gentlemen of the jury, we have now, as you know, completed the state's portion of the case. The state has rested. And as I advised you at the very beginning, the defense has an opportunity to put on a defense if they wish. They will be calling witnesses, so we are now in that portion of the case called the defense's case. And with that, Mr. Waheed, does the defense have a witness to call?
Yes, Judge.
All right.
This time, the defense calls Kellen McCoy.
Okay. All right. Before we administer the oath to Ms. McCoy, this testimony is being conducted via Zoom by agreement of the parties. The witness will be sworn in. And again, you are to view and consider and listen to the testimony the same as you would if this person was sitting right here on the witness stand here. Everybody understand that? Okay. All right. So, ma'am, I'm going to go ahead and administer the oath. If you could raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right, Mr. Waheed, you may proceed.
All right. So, and it's a little weird. I'm not facing anywhere, but I'm actually facing the camera. So hopefully Ms. McCoy is looking at me as I ask the questions. Ms. McCoy, if for some reason through technology you don't hear what I say, please, ask me to repeat it. And of course, if I ask a question that doesn't make sense, which happens a lot, just go ahead and tell me to repeat that as well. Ms. McCoy, can you?
I think I'm going to make it easier on you. I'm going to switch the video for her so she just look right at that video there.
Okay, great.
All right, you have to proceed.
Can you please state your full name?
Kellen Marie Hynum.
And what was your maiden name?
McCoy.
Okay. So currently, are you working?
No.
You're home with a fairly young child, correct?
A couple, yes.
Okay. Back in 2018-19, were you working as a teacher?
Yes.
Okay. How long were you teaching?
At that point in time, maybe four or so years.
And what city did you live in at that time?
Tucson, Arizona.
What school did you teach at?
Immaculate Heart Academy.
Was Immaculate Heart is that a private school, public school?
Private.
Okay. And what grades did you teach back then?
I taught second grade, third grade, and fourth grade consecutively.
And do you recall in 2018-19 school year, what grade were you teaching?
I'm not certain. It was either third or fourth grade.
All right. So, do you know the name Ferriter?
Yes.
Okay. And how do you know her?
She was a student of mine.
And do you remember when that was?
2019.
In 2019?
I believe 2019.
Okay. Was there ever some moment where his brother comes into your classroom and asks you to make an announcement? Do you recall that?
Yes.
Do you recall when that was, approximately?
Can you repeat that question?
Sure. Do you recall when, approximately, what month and year that happened?
Off the top of my head, I can't remember for sure. Maybe February of 2019 or March.
All right. And would it help to refresh your recollection if you had something to look at from that time?
Yes.
So earlier today, my office should have emailed you a document. If you take a look at that and tell me if that refreshes your recollection as to the time frame we're talking about.
Yes. 1 second.
sorry?
March of 2019.
All right, so March of 2019. All right. And tell me what you recall happening between and in your class.
He came into my classroom and asked if he could make an announcement to my class, which at that point in time, it was a regular thing for teachers to send students to other classrooms to make announcements. So I said, yes, you can make an announcement to the class. So he walked to the front of the class and started to say things where I quickly realized he was not sent by another teacher. He said some things to humiliate her in front of the whole class. He made her cry. And once I caught on to the fact that he was not making an announcement sent by another teacher, I stopped him and I asked him to go back to his own classroom.
And did he leave?
Yes, he did.
Did you notice any response from?
Yes, she was very, very upset. She was crying, and it took a while for her to gain her composure.
What was your impression of that whole incident? I'm sure.
Sustained.
Had you?
My impression.
Had you? I'll ask another question. Had you ever had something like that happen in your class before?
Sustained.
Based on what happened, did you do anything next? Did you reach out to the parents?
Yes, I did.
And
I sent them an email.
Generally stating what had happened, correct?
Yes.
Okay. And what, if anything, was their response to you notifying them of this action?
They came in immediately, I believe later that day, to talk about it. They had requested that they meet separately. So first I met with mom and talked to mom about what had happened. And then after that, I met with dad separately to talk about it. And while I was talking to each parent, the kids were waiting by themselves, either in the hallway or in their car. I believe I may have been in the car while mom was having a meeting with me, or in the hallway, and was in the hallway while I met with dad.
So let me talk to you about the dad response, Tim Ferriter's response. When he met with you, when you conveyed, so let me ask you, what is it generally he wanted to know about?
Both.
Trying to avoid the hearsay, just generally.
I'm going to overrule the question as phrased, but ma'am, you're not to say what Mr. Ferriter said. You're only supposed to state what your understanding was that he wanted to know. You can answer subject to that limitation.
So what did he want to know?
Can I continue?
Yes.
Yes, you can state what was your understanding of what he wanted to know.
My understanding is that he wanted to know the facts of what happened. He seemed concerned and wanted to just understand what the situation was. And he was very...
Go ahead.
He seemed very receptive and understanding of what had happened.
Did he, in your presence, ask you any follow-up questions regarding trying to determine if there was any punishment from the school, detention, or if the school was taking any action against Ronan?
Not that I can recall.
And did he give you some indication that they would handle it as a family at home?
That was my impression, although he didn't I don't remember him stating anything directly saying what they were or weren't going to do at home.
Was there any impression you got from that interaction as to what, if anything, he was going to do next?
Objection is speculation.
Sustained.
No.
Based on that interaction, so you had a separate interaction.
Mr. Wade, let me just make sure the witness knows. When I sustain an objection, ma'am, that means you're not to answer it, okay? Do you understand that? And I sustain the objection to the last question, so the answer is stricken. Jury is instructed to disregard it. You may continue now, Mr. Wahid.
Sure. You had a similar conversation with the mother, correct?
Yes.
Did the mother also inquire of you as to essentially facts of what happened?
Yes.
Based on that interaction, did the mother give you any impression as to, or ask you if there were any consequences at the school that were going to take place?
Not that I can recall.
And continued to be a student in your class, correct?
Yes.
One moment.
Granted.
No other questions for this witness. Thank you.
All right, any cross by the state? All right, Ms. Coakley, you may proceed.
You were his fourth grade teacher, right?
I believe so, yes.
And at the time that this happened was also in elementary school, correct?
Yes.
So like he was one grade above us, so he was a fifth grader at the time that this happened?
Yes, I believe he was in fifth grade.
So he was approximately 11 years old when this happened, correct?
That sounds right, yes.
And the date that it happened is March 22nd, 2019, right?
Yes.
And you sent an email to the parents, correct?
Can you repeat that?
You sent an email to the parents to notify them of the incident involving their children, correct?
Yes.
And you told the parents that what occurred is that came into your classroom and asked to make an announcement.
Let me stop you there. Ma'am, it looks like you're typing on a keyboard and you cannot be reading anything or typing anything while you're testifying. So just please acknowledge to me that you're not reading. Yes, it looks to me like your hands were moving. All right, I just want to make sure. Anytime I'm doing remote testimony, I just need to make sure the witnesses understand the restrictions that you cannot be reading anything or typing anything or communicating with anyone else. You understand that?
I understand that. I'm just watching my kids.
Okay, perfectly understood. But anytime the eyes start darting away, I have to be careful that you're not getting improper influences. So you may proceed. I just want to make sure you understand the instructions.
And what was said in front of the class was, I've gotten several reports about stealing in this class. Stop. Just because I'm your brother doesn't mean you can do that. And then he asked to stand up, correct?
Yes.
And that made him cry, correct?
Yes.
That's all that he said, correct? Before you stopped him.
No, that's not all that he said. Those are just the specific words that I remembered as I was typing that email.
Okay, that's all the information that you provided to the parents, right? That he came into class and he accused his little sister of stealing, correct?
That is all the information I provided in the email. Yes.
Now, you did speak with the parents, correct?
Yes.
You were not aware at the time how he was being treated by his parents at home, correct?
Correct.
You also are not aware of how the parents chose to punish their 11-year-old son for this infraction, or are you?
Correct. I was not aware.
They didn't tell you what they were going to do with this information, correct?
They did not tell me.
That's all the questions I have.
All right, any redirect, Mr. Waheed? All right, you may proceed.
Ma'am, the state referred to this as an infraction. At the time when it happened, is it, in your mind, was this an infraction or a prank or something like that?
Objection, Your Honor. Relevance?
Overruled. You can answer.
Can you repeat the question?
Sure. The state, just when they asked you, referred to this incident as an infraction by, and I'm asking you, at the time when you were there, was it your perception this was an infraction or a prank or something minimal like that?
What's the definition of an infraction?
Sure. So, did you think this was just a prank between siblings? Did it come across to you as that, as something in play?
No, it didn't seem like a simple sibling prank to me.
And why?
Sustained.
No other questions.
All right, thank you, Mr. Waheed. All right, ma'am, that concludes your testimony. That means that you may sign off and your testimony is concluded. She's excused from further proceedings, correct?
Yes.
All right, you may sign off, counsel. Ma'am, thank you.
Thank you.
All right, Mr. Waheed, your next witness.
I'd like to call Steve Johnson. Steve's phone is sideways, apparently.
All right, Mr. Johnson, can you hear me? Let me put him back in the waiting room.
I see him in the corner there, Judge.
All right, Mr. Johnson, this is Judge Coates in Palm Beach County, Florida. Can you hear me, sir?
Yes, I can.
Okay, all right, you've been called as a witness in the matter of State versus Ferriter. First order of business is for me to go ahead and administer the oath. If you could raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, all right, Mr. Waheed, you may begin.
Thank you, Judge. Sir, can you state your name and what city you currently reside in?
Sure. My name is Stephen Johnson. I live in Tucson, Arizona.
And how long have you lived there?
My entire life, 40 years.
Are you currently employed?
I am.
Generally, what type of work do you do?
Director of business development for a pain clinic.
Do you have any children?
I do.
How many children do you have, sir?
9.
9 children. You're busy.
Correct. Yeah, apparently.
Do you know someone named Tim Ferriter?
I do.
And how do you know him?
I met Tim back in 2017 at a basketball camp for our daughters when he first moved here.
Here being Tucson, Arizona, correct?
Correct, here being Tucson, Arizona. And then subsequently learned that his children were going to attend the same school as mine, Immaculate Heart in Tucson.
And what would you say was the frequency of contact between you and Tim Ferriter back in those years?
At first, not much, but he and I coached basketball together for 2 seasons. We coached our daughters. And so that would have mean I would see him probably 3 or 4 times a week.
And do you recall his son?
I do.
And do you recall when approximately when or how you first met?
I met him at one of the practices, his dad introduced him, and he sat and watched the practice. And then he was also in my son's class at school.
So your son and his school went to school in the same class?
That is correct.
At any point, did you go to Tim's home?
I did.
And can you tell me what those occasions were about? Why'd you go?
Initially, they were social. There were for some kids' birthdays and the baptism of their youngest. And there were a few times that I was over there for business. Tim was a publisher of a magazine, and I was learning how that worked from him at his home during the day.
And so did you at any point see the inside of Tim's house?
Yes.
Did you ever were you ever shown the room?
I was. That is correct.
Who showed you that room?
I believe Tim would have given me a tour my first time there.
All right. Did you at any point at that time, do you recall interacting with him yourself directly?
Yes. I did interact with him several times. He was always out with the family and the guests when we were over there.
Okay. In your interactions with Tim during that time, did he seem guarded or any way secretive about his family?
No.
And did you ever have occasion to see or interact with him enough to get a gauge on his behavior?
I did, and was always pleasant. He'd always have kind of a sly smile on his face. He was talkative, so we connected pretty easily.
And did you and Tim and your son ever collectively engage in anything?
Perhaps within those social settings, we never had anything particular for the four of us.
And I know you guys were teaching, we're coaching girls basketball.
Yep.
And do you know if either did you ever see or know that was engaged in any extracurricular activities back then?
No, I know that he didn't play any sports.
Right.
That I do know.
Did you on any occasion see the interaction between Tim and...
Yes.
How would you describe that interaction?
Oftentimes, because I would sit and watch the practices, there would be some times when Tim would go over to help him with homework or something that he needed, common if a kid is near a parent. There were times when we would be at a game and I'd show up and I'd notice that he had a notebook out and he would be writing, "I will not hit my sister," like 50 times or whatever the number was. And the reason that's...
Mr. Johnson, there's been an objection. You cannot say what someone said or what they wrote. That's hearsay. That part of the answer is stricken. The jury is instructed to disregard it. All right, you may continue with your next question, Mr. Waheed.
Without saying what he was writing, you saw him writing things at the practice, correct?
Correct.
Okay. And did you have any understanding of why he was doing those writings?
I did.
And what was your understanding?
I'm going to sustain it, but approach, because you may have an exception you're going to rely on. All right, so the objection is sustained. Next question, Mr. Waheed.
Sir, did you observe Tim be affectionate to?
Objection relevant.
Sustained.
Did you ever observe Tim disciplining?
Yes.
Did you observe an interaction between them where Tim was not disciplining?
Yes.
Would it be fair to say that they, in your mind, that strike that? Did show affection for Tim?
Objection relevant.
Yes.
I overruled. I'll allow that question.
Yes.
Did you ever observe Tim disciplining the other children in his family?
Yes. Yes.
And just so we're clear, you knew Tim and you were interacting with Tim during 2017, correct?
Correct. Yes.
2018?
Yes.
And into 2019?
Yes.
Until his child left Immaculate Heart and went to another school?
Until they left for Florida, I believe.
Okay, so even when switched schools, you were still interacting with Tim and his family, correct?
Correct.
No other questions?
Thank you, Mr. Waheed. Any cross? Yes, Your Honor. All right, Ms. Black, you may proceed.
Good afternoon, Mr. Johnson. Can you hear me?
Yes, I can. Good afternoon.
Okay. So you stated that you kind of became friends with Mr. Ferriter back in 2017?
Correct. Yes.
Okay, and you both coached your daughters in basketball?
Yes.
Okay, you stated on direct that you had seen his room, right?
Yes.
And that was inside of the house?
Correct.
And that was before he had been born, right?
That is correct.
Okay, so you don't know where he was living after he was born?
That is correct.
You also stated that you did not see a structure in the garage, right?
That is right.
Okay, and you didn't really have any contact with Mr. Ferriter when he had decided to move to Florida?
Aside from a few text messages wishing things like Happy Thanksgiving, no.
Okay, so you never went to his house in Jupiter back in December of 2021?
That is correct.
You never saw where he was living at that time, right?
That is correct.
You never saw the structure where he was living in, right?
I'm sorry, one more time?
You never saw the structure that he had been living in 2021?
I did not.
And you weren't made aware of how the defendant had been disciplining him at that time, right?
I had not been made aware of any specifics.
1 minute, Your Honor.
Granted.
I have no further questions.
All right, any redirect, Mr. Waheed? All right, thank you, Mr. Waheed. Mr. Johnson, that concludes your testimony. Is this witness now excused? Yes. Okay. All right, sir, your testimony is concluded, so you can go ahead and sign off Zoom. Thank you for being here. Have a good weekend.
Thank you, Your Honor.
All right, Ms. Murad, Mr. Waheed, call your next witness.
That's called Saad D. Barzadi. Saad D. Barzadi. Saad or
And Mark, when you come in, you can go ahead and change the input on the screen so the jury's not burdened with the Zoom link.
Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
All right, Mr. Waheed, you may begin at your convenience.
Sir, can you state your name and spell your last name for us?
Sev Debazati, D-E, B for Bob, O-R-Z-A-T-T-I.
And where do you live?
I live in Melbourne, Australia.
And how do you know Tim Ferriter?
Yes, I do.
And how do you know him?
I met Tim when we were at seniors in high school in 1992. I was an exchange student. I met Tim then, and we've been friends ever since.
Where was that?
That was in Milford, Michigan.
Okay. And over the years, you and Tim have interacted continuously, correct?
Correct. We've probably seen each other on 9 or 10 occasions in person, and we've stayed in contact via phone and FaceTiming with our kids and so on and so forth.
And your children know his family, correct?
Correct.
And you actually visited his house in 2013, correct?
Correct.
And then again in 2019, correct?
Correct.
All right. So I'm going to take you to 2019. Mm-hmm. So in 2019, tell me if you remember approximately when in the year did you visit his house?
It would have been July.
Right.
Sir, move up to the mic just a little bit closer and speak a little bit louder. I want to make sure you're getting accurately recorded.
Sorry, July.
All right. And where was that home?
That was in Sedona.
The home was in Sedona?
Yes.
Was the home possibly in Tucson?
Tim's home was in Tucson, but when I first got there, we went to Sedona.
Understood.
Yeah.
Okay, so let's start with Sedona. So you were with your family?
Correct.
And how many children do you have?
3 children.
Okay. When you went to Sedona, were you with Tim's family?
I went with Tim. Tim met us in Phoenix. We drove up to Sedona to meet Tracy.
And what type of structure did you all stay in?
It was a 2-story home. Tim and his family stayed on the top level, and my wife and my kids stayed on the bottom level.
And do you know where did you sleep during that time?
I slept in the master room with Tim and Tracy.
And how long was that time that you guys were in that house in Sedona?
Approximately 5 days.
All right. It was just a vacation in Sedona?
Correct. We went there, had a softball tournament. So obviously Tim and Tracy took her around to all the softball tournaments that she could play, and it was a big one, and they invited us to come down and spend some time and do that. So we went down there for the softball tournament. Yep.
All right. Subsequent to Sedona, where did you all go?
We hired an Airbnb in Tucson, 2 or 3 minutes from where Tim and Tracy live.
Did you, on that trip, have occasion to go to Tim's house?
Yes, I did.
And when you went to Tim's house, did you look around the house?
Yes, I did. Tim showed me around.
And did you interact with him on that day?
Yes, I did.
And what, if anything, did you do?
Just normal kid. He spoke to me and showed me around, showed me his room, as all the kids did, and was happy to show me and was excited and showed me his toys and books and so on and so forth.
And where was his room?
His room was in the garage.
All right. And did you have any occasion to see interacting with your children?
Yes, I did.
And one of your children is a special needs child, correct?
Correct.
And what's that issue, if you can tell us?
My younger son has autism.
All right. So in the interaction that you observed between and your children, did anything occur that concerned you?
There was an incident in the pool where, would be overly aggressive, duck the children underwater and hold them down there for a little bit and so on and so forth. So yeah, but I mean, I was there, so I was there to protect and look after them, but I wouldn't have left my children alone if it was just grown kids.
So don't kids play like that, putting their heads underwater, that sort of thing?
I think when both of them choose to do it together and they play, this was more just one pushing the other down against their will.
And with your special needs child, did that give you any extra cause to pause?
Just maybe keep an extra eye out, just to make sure everything was okay, and I kept an eye on where he was and where the rest were.
Were there decisions made about going out for dinner or things like that with the Ferriters that factored in any way?
We always went out together, so we never left any of the kids behind. We were always as a group, as a family. We went out together, we ate together, we swam together, we played together, we did everything together as families.
All right. One moment. Going back to Sedona for a moment, was there ever an incident there that happened with that caused you concern?
When we were leaving and we were packing up and I guess checking the house before we left, we noticed there were knives missing from the kitchen. So we started to look for those to make sure we put those back and find out where they were. We couldn't find them, and then Tracy went into his bag to have a look and found the knives and brought them back. And we put those away. So there was probably a handful of knives that were missing and found in his bag.
No other questions.
Any cross? All right, Ms. Black, you may proceed.
I just want to get your last name right. It's Mr. Debrazzati?
Debrazzati, yep.
Debrazzati, okay. So when did you first meet Mr. Ferriter?
1992.
And you've been friends ever since?
Correct.
You stated that you visited his house back in 2019?
Yes.
And this was after the vacation you guys had taken to Sedona?
It was right after.
Okay. So you stated that you saw his room, right?
Correct.
And did you stated that it was in the garage?
Yes.
Okay. Did you see if there was a bucket in there?
No, I did not.
Okay. Did you see whether or not the door locked from the outside or the inside?
The door was open, so I was unaware of any lock.
Okay. Did you see if there was a light switch inside the room?
I didn't look.
Was there a bathroom inside of that structure?
There wasn't a bathroom in the structure, no.
Now, you stated about an incident with the kids in the pool?
Yes.
Okay. And isn't it a fair assessment that they were just horse playing in the pool?
Yeah, like I said before, I would normally say that if there was two interacting together and playing, but this was more one imposing his will on the others. The girls didn't really want to play. They didn't want to be ducked or really horse played, but he continued to do it. So.
How old was he at that time?
I think he was 11.
So he's basically being like the annoying older brother at that point.
Yeah, annoying and yeah.
But you were there to protect them if they needed to be protected.
Absolutely, I wouldn't have left.
You also talked about an incident with some knives.
Correct.
Okay, and the fact that Tracy had taken them
From his bag.
He didn't threaten you with those knives?
No,
He didn't threaten the kids with those knives?
not that I'm aware of.
He didn't threaten Tracy with those knives?
Not that I'm aware of.
It's just that he had the knives and she took them out of the bag.
Correct. Yeah. So I don't even know if he knew how long he had them for.
Now, did you ever visit the Ferriters' house in Jupiter in 2021?
No.
Okay, so you don't know what the living arrangement was at that time?
No.
You don't know if there was a similar room that there was in Arizona in Jupiter?
No.
Woman, Your Honor?
Granted.
I have no further questions.
Any redirect, Mr. Waheed?
Yes, Your Honor.
All right, looks like you do, so you may proceed.
Sir, would you have left your kids with unsupervised?
Objection, relevance.
Absolutely not.
Overruled.
I'm sorry, sir?
Absolutely not.
And why not?
I would think it would be unsafe.
Thank you.
All right, is this witness testimony concluded at this point? Yes. Excused. All right, sir, that concludes your testimony. You may step down. Thank you for being here. Call your next witness, Ms. Murad or Mr. Waheed. Are you doing the direct, Ms. Murad?
Yes,
okay.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Murad, you may begin.
Thank you, Your Honor. No worries. Sir, could you state your name for us, please?
Yes, is the microphone all right?
Yes,
it is.
Stuart Graham, like the cracker, Graham.
Dr. Graham, could you take us through your educational experience?
I can. I have a baccalaureate degree from the University of Texas at Austin in microbiology. I have a medical degree from the University of Texas Medical Branch in Galveston, Texas. I completed 2 years following medical school, postgraduate training in anatomic pathology at Case Western Reserve in Cleveland, Ohio. I am a pathologist by training. The one part of after medical school of training in pathology is called anatomic pathology. That's the specialty of pathology that most people think of as being real pathology, where you perform autopsies, you receive specimens, you look at those specimens under a microscope, and you then reach conclusions regarding disease. Following completion of 2 years in Cleveland, Ohio, in anatomic pathology, I then completed 2 additional years of training in clinical pathology at the University of Texas Health Science Center in Houston, Texas. Clinical pathology is another branch of pathology which deals with the study of disease in human beings. It differs, though, in anatomic pathology, in that rather than looking at portions of the body either with the naked eye or under a microscope, the disease processes rather are studied by the use of laboratory tests. and the part in clinical pathology deals with the implementation of laboratory tests and the interpretation of laboratory tests. Following those 2 years, so now we're 4 years following medical school, I completed a 5th year of training after some time in the subspecialty of forensic pathology. I completed that training at the Office of the Chief Medical Examiner in the city of New York. Forensic pathology, as you may know, is the area of pathology which deals primarily with the interaction of disease and injury in the human body. And as such, forensic pathologists are often asked to make determinations with regard to what natural disease did a person have, what injuries did they have, and what was the result of those natural diseases and or injuries. I would say that the injuries can be of a variety of sorts. They can be, of course, violent, either with a hammer, with a knife, or with a gun. But injuries can also be those of withholding things, such as food. It's possible to starve a person to death. Following completion of that fellowship, I then, after that, sat for the American Board of Pathology certifications and passed those my first time in anatomic pathology, clinical pathology, cytopathology, and forensic pathology. After completion of and receipt of my certifications, I've been active for the past, gosh, I am old, 30 years in both the 30 years in the performance of surgical pathology, which involves the study of specimens from live patients, and for 13 years in forensic pathology, which, as I said, is a little bit different of a specialty, which involves the inclusion of injuries as well. At this time, I most recently now work as a forensic pathologist in a variety of capacities. I do per diem work. Most recently, last year, I was at the university. At the last year, I was in Webb County, Texas, on the Rio Grande, working as a medical examiner for 3 months, which, as you can guess, was quite busy. I also perform private postmortem exams on behalf of families and hospitals. And finally, I do consultations both in civil court and in criminal court, as we are here today.
And in this case, were you hired by my firm to review some records and come to an opinion regarding a particular issue?
I was.
Okay. Could you take this jury through the records that you reviewed?
I will. The records I reviewed were the Palm Beach Sheriff's Office of offense report, the Children Protection Services report. There were some photographs associated with the Children's Protective Services report. There were health records from JFK North. There were also pediatric records from Infants and Children's, which is a large group of pediatricians which took care of. And I believe that's about it.
So I want to talk specifically about the Infants and Children's records. What years do those span?
Well, the records span. The records span from the time that is 8 years 8 months up until the time that is 13 years 3 months, or thereabout. In other words, approximately from June 1 of 2016 until December 21st of 2021.
Okay. Based on those records, what is your opinion regarding nourishment, health, and weight?
Based upon those records, it's important to note that the records include within them a calculation which is endorsed by the Center for Disease Control and Prevention, the CDC, and because that the assessment of nourishment is a national of national importance in pediatrics, there's a standardized way of doing it, and for each child, for their particular sex and their particular age, a calculation is performed that's called a body mass index. Well, we can call it BMI for short. But the importance of the BMI is that it takes the person's height into account and their weight to give a calculation so that for a person's sex and age, you can compare an apple with an apple. And so that you're not comparing a child's weight without relationship to their height, which obviously would cause obvious problems. The BMI then, which is endorsed by the CDC, those records were included in the ones that I reviewed, and there's a chart, and the chart shows that in 2016, when he was 8 years, 8 months old, his BMI had a numerical value of 40. Later, in December of 2021, his BMI had risen to a value of 56. Now, it's perfectly fair for you to ask me, well, what does 40 mean and what does 56 mean? It's actually quite simple. For a BMI of 40, it would mean that at least for boys of his age, which would be 8 years, 8 months, at least 39% of the boys would weigh less. For a BMI of 56, it would mean for his age at that time, which was in December of 2021, that at least 55% of the boys would have a BMI of less than 56. That clearly, by the definition of the Center for Disease Control, means that BMI was completely normal, in fact, right smack in the middle.
What does that tell you about, I mean, is there any evidence of malnourishment in the record?
No, there is not. By the records that I reviewed, his most recent BMI of 56, he has a weight at that time of about 113 pounds, 4 ounces. In order to be judged to be not of a healthy weight, he would have to lose over 18% of his weight. So he's well outside the guidelines for being underweight.
Okay, and is it fair to say that there's no evidence in the record that he wasn't being fed?
Sustain, rephrase with a more specific period.
In the records that you viewed from 2016 to 2019, you said there's no evidence of malnourishment, correct?
Yes, I said there is no evidence of malnourishment as judged by the BMI charts. For the question, that you just alluded to, when people are deprived of food, they lose weight, and that mathematically causes their BMI to decrease so that then it is no longer within normal range.
And based on the records that you reviewed, which again are from 2016 to 2019, is regularly being taken to the pediatrician.
Yes, although the records actually, I think, extend to 2021.
Thank you. No further questions.
All right, any cross? All right, is this witness excused, Ms. Murat? Yes. All right, sir, that concludes your testimony. Thank you. You may step down and have a good weekend.
Thank you very much.
Thank you.
And Your Honor, that concludes our witnesses for today.
Okay.
The defense does have additional witnesses, as the court knows, but they're
Okay. All right, so ladies and gentlemen, that means that we're going to conclude the proceedings for today. As I've already given you the heads up, we'll start back on Tuesday. We're going to start at 9 o'clock sharp on Tuesday, so check in with the jury office no later than 8:30 and be up here at the elevators meeting mark at 8:45 for 9 o'clock sharp start time. And the schedule next week will be likely as follows. Tuesday will go from 9 to 5. Wednesday likely from 12 to 5. And then Thursday, if that's necessary, it would be another 9 to 5 days. So that's kind of the schedule that I'm anticipating. There's still a little bit of movement potentially in the Wednesday schedule as I get more visibility when I get into next week. But that's the current, and I know you're probably not totally confident in my estimates anymore, but that's my estimate for next week. All right, so Monday's a court holiday, so you won't be back on Monday, obviously. It's going to be 3 days. So during the 3 days, rest, relax, and sun. Hopefully the weather is good this weekend, but make sure that you do everything possible to avoid any inadvertent media exposure during the what's going to be the long weekend, holiday weekend for us. So with that, I wish you the best, and I'll see you back on Tuesday morning, same courtroom. All right, everyone may be seated. Okay, so my expectation, based on what I'm hearing, is that the defense will likely rest on Tuesday. Is that a fair assumption or fair estimate on my part?
I think it's a fair assumption, Judge. I am working on some videos that we want to play.
Okay. Yeah, I'm not holding you to it. The only reason I raise it is that because it's at least a possibility, then we need to come Wednesday armed with the necessary jury instructions in case you do rest early enough in the day. Now, if you finish late in the day, we would not start closings. I would wait until the next day to start closing. So let me, just for planning purposes, has either side given thought to how long they think they're going to need for closing arguments in this case? At least an hour and a half. All right, so about 3 hours. So if we finish the evidence on Tuesday, and then if I start at noontime on Wednesday, that gives plenty of time for the closings to occur and then for the jury to have the case for a couple hours during the day Wednesday. And I've already set aside the entire day Thursday for deliberations, if they need it. So, all right, well, that's the plan for everyone. Same instruction to you guys. Go home, rest as much as you can, and relax. And I'll see you on Tuesday morning for a 9 o'clock sharp start time. And I don't have a morning docket next week because I was supposed to be on vacation. So that's all right. So I'll be starting at 9 o'clock sharp. There won't be any built-in delay because of my morning docket is what I'm letting you know. Okay. All right. I'll see everybody next week.